Good morning. I call this meeting of the Privileges and Elections Committee to order. And if the clerk will please call the roll. And members, cast your vote for your presence. Okay, if the clerk will please close the roll. And we do have a quorum. So I want to welcome everyone who is in person and who is watching. And with that welcome comes a reminder that we do have rules that govern how we do business here in the House of Delegates. So the first reminder is to please speak through the chair. So you will direct your comments to me. And there is one person talking at a time, and that's the person that I've called on and recognized at that time. And I definitely understand that each of us feels passionately about what it is that we wish to say, but we will have respectful debate at all times in this meeting. Each patron will introduce their legislation, introduce any amendments, then we will take questions from the members, and then we'll have public testimony. And we'll have public testimony in support in person, then opposition in person, then we'll go online for support, and then online for opposition, and then we'll give the patron a final word before taking any motions. For our meeting today, we will be considering 3 proposed constitutional amendments that were carried over during the 2024 legislative session. And so it is our duty to do our due diligence to act before the deadline of November 18th. So we are here to finish that business as stated in our rules and agreed upon in January. Are there any questions from the members? Seeing none, we will hear House Joint Resolution 2 with Patron Delegate Elizabeth Bennett Parker first. Please come forward. You have the floor.
I'm trying to, is the mic working? Okay, thank you. Sorry, the light isn't on. Thank you, Madam Chair. This is House Joint Resolution 2, a proposed constitutional amendment. It provides an affirmative fundamental right to vote for qualified voters. It also provides for the automatic restoration of political rights once a person with a felony conviction is released from incarceration, and also strengthens protections for individuals with disabilities. The language is the same as what passed the House and Senate with bipartisan support in 2021. Virginia is the only state to permanently disenfranchise all individuals with felony convictions unless they individually petition the governor for rights restoration. The disenfranchisement of people with felony convictions is a relic of Virginia's Jim Crow past and was intentionally inserted into the 1902 Virginia Constitution to disenfranchise as many Black voters as possible. Today, more than 1 in 7 Black Virginians is disenfranchised, which is twice the national average. Automatic restoration of voting rights encourages voting and civic engagement, which research shows benefits reentry, reduces recidivism, and makes communities safer. So all Virginians would benefit from this change. The proposed amendment also strengthens protections for individuals with disabilities, ensuring their voting rights are lost only if a court adjudicates that the person is incapable of voting or understanding the act of voting. This contrasts with our current process, whereby when guardianships are set up, those under them lose the right to vote. You can be deemed legally incompetent to manage a checkbook and inadvertently also lose your right to vote. Under the amendment, a court would have to say you don't understand the act of voting before you lose that right. This amendment is important to many Virginians. I've spent most of my career working with women who were previously incarcerated, and they've shared with me what regaining the right to vote means to them. We also have advocates here with us today who have been personally affected. I think it's important for the committee to hear about their experiences, and I'm happy to answer any questions. Thank you.
Thank you. Committee, are there any questions? Please use your request to speak button. Seeing no questions. And you said you had a witness with you?
Yes, I believe there are folks.
If they could come on forward, please. Just the one. Just the one. I'll call for the rest. Good morning. Good morning.
Good morning, Chairperson.
I'm so sorry, are you part of the public testimony or a witness specific to the patron's introduction?
Not specific to.
Okay, go for it.
Good morning, Chair Price and committee members. My name is Sheba Williams. I am the founder and executive director of No Left Turns, the mother of a 23-year-old son who is autistic, a member of the Virginia Right to Vote Coalition. And 20 years ago, almost to the date, I was wrongfully convicted of a felony conviction in the state of Virginia. I lost my right to vote, to serve on a jury, to be a notary, and to run for public office due to this wrongful conviction. While I was sentenced to 5 years of probation, I lost my civil rights for 9 years due to inability to afford fines, fees, and restitution. My civil rights were reinstated in 2013 by Governor Bob McDonnell. In 2013, after 24 years, my mother also regained her civil rights. In 2023, after being released from incarceration for 16 years, my father was able to vote for the first time in 34 years. Their substance use was not met with treatment and support. It was met with handcuffs and over 46,000 collateral consequences. The organization that I lead has assisted thousands of Virginians with reinstating their voting rights. In fact, in 2021, coming before this same subcommittee, education about Virginia's policy on indefinite probation led to Governor Northam reinstating the rights of 69,045 eligible individuals. The Right to Vote Coalition is comprised of multiple partners from across the country and partners that cover each corner of our state who have fought for this constitutional amendment for well over a decade. Every voice in our democracy must be heard and included. That includes Virginians who have been convicted of felonies, who have been released from carceral facilities. We are not defined by our past mistakes. We are business owners, community leaders, church ministers, parents, and neighbors that deserve to have a say in the future of Virginia's communities. Virginia permanently disenfranchises its citizens and places the sole authority in one person's hands. It is well past time for Virginia to amend our Constitution to create a stable restoration process that reflects fair accountability and encourages civic engagement. Thank you.
Thank you. So we'll, absent of any questions, okay. So we will go to public comment. Oh, excuse me. Delegate Bloxham.
Thank you, Madam Chair. I do have a question for the patron. I just want some clarification if I could. Incarceration, probation or restitution isn't mentioned here. It's just incarceration. So if someone is convicted of a felony but is not incarcerated, then they would be able, they'd never lose their right to vote.
Madam Chair, to the delegate, I would say that right now, Virginia is very clear that their right to vote is only lost for felonies. And so incarceration is being in a physical institution under the amendment. Once you are released, you will have your rights restored. Individuals who are released from incarceration are in society, they are paying taxes, they are otherwise participating in society. They should be allowed to decide who has the, who represents them on city councils, on school boards, and all government positions.
Follow-up question, please?
Delegate Bloxham.
Okay, I really have no issue with any of that. My more problematic problem with this thing is restitution. So there's a victim of this crime that is owed money, but there's no mention of restitution. Would that be settled, I guess, at the beginning, at the sentencing? Or, how would that be handled? Because it looks like to me that the victim is still sitting out there without being restored.
Madam Chair, to the delegate, I would say that denying the right to vote based on the ability to pay creates a modern-day poll tax, which unfairly penalizes those who want to fully participate in society, have completed their period of incarceration, but are not yet able to pay off resulting debts. The right to vote should be fundamental and should not be subject to financial barriers. Again, these are folks that have reintegrated into society. They're participating in society. We want to engender their full participation in society, because we know that that encourages a sense of belonging and reduces recidivism.
Delegate Gilbert.
Thank you, Madam Chair. I just want to follow up on Delegate Bloxham's first question, which was whether, and I think you're making some assumptions to the patron, that most people convicted of a felony are somehow going to jail and getting out. or going to prison and then getting out. And I would respectfully submit that most people convicted of nonviolent felonies do not ever serve a day in prison unless they mess up on probation. So the Delegate Bloxham's question was, if you have no other penalty and you still owe a bunch of restitution and you've never gone to jail for even a day for this felony you've convicted, is it true that your resolution would mean that you would never even also lose your right to vote?
Madam Chair, again, to the delegate, I would reiterate that this is about a fundamental right to vote and participation in democracy, and that folks that are in society, that the amendment is very clear that you are, once you are released from incarceration, you have your rights restored. And so if you are released from incarceration, you are participating in society, you are paying taxes. This is about empowering the right to shape your community and to fully participate. And again, research shows that that reduces recidivism, which saves taxpayer dollars and is a benefit for all Virginians.
I hear you, though.
Delegate Gilbert.
Madam Chair, again, respectfully to the patron, I think you're still making the same assumptions that you are being released from incarceration. That is an inaccurate assessment of what happens to most people convicted of nonviolent felonies, and perhaps even the bulk of felonies for at least their first offense. Does your amendment also apply to those people who face no other consequence other than the felony conviction itself, that they also essentially never lose their right to vote, in addition to all the things that aren't going to happen to them, including being incarcerated? They get to vote right away, right?
I'm sorry?
They get to vote right away, regardless of their felony conviction. If they never go to jail, they can keep voting, and there's no other consequence.
Madam Chair, to the delegate, I think we're going around and around here. I would say that the amendment provides a restoration of rights when someone completes their period of incarceration. If they have not been incarcerated, they would retain the right to vote.
Okay, thank you, Madam Chair.
Any other questions from members? Okay, if you are in the room to speak in favor of House Joint Resolution 2, if you will please raise your hand. If you are in the room to speak against it, if you will please raise your hand. Okay, so we will set a timer for 15 minutes. And if you are in favor and in person, please come line up at the podium. And then after the in-person testimony, we will go to online, please. And be mindful of the others as we use our time.
Good morning, Madam Chair, members of the committee. Tram Nguyen with New Virginia Majority. We are strongly in favor of this amendment. We've been working on the right to vote for amendment for nearly 18 years, starting with the late Yvonne B. Miller, and we're proud to stand with our community members and partner organizations to carry on the fight in her memory and legacy. Over the years, we have helped restore and register over 30,000 people who are returning citizens to vote. They come from all walks of life, but the majority of them are people of color, particularly Black men, who are overrepresented in all steps of our criminal legal system. It is clear that Virginia's felony disenfranchisement laws are an extension of Virginia's Jim Crow era, and as we fight to address systemic racial inequities, the right to vote is a key part of that struggle. So it's long past time for Virginia to establish a constitutional right to vote, and we strongly support the amendment. Thank you.
Thank you.
Hello, Madam Chair and Committee. My name is Chris Kaiser, and I'm Policy Director with the ACLU of Virginia. We're here in strong support of HJ2. This is a vital pro-democracy measure, and look forward to seeing it pass. Thank you very much.
Good morning. My name is Lisa Kratz-Thomas. I am a reentry consultant with the Department of Corrections. I am a former offender, and I've worked with offenders for 27 years. And when you get a felony conviction, you get your rights back when you complete the consequence to your action, whether you're incarcerated or not. My rights were restored when Governor Warner was the governor. I had to do the long form, and I got it restored. But today, my question is always, when is enough enough? When is it enough that we have completed our jail sentence or prison sentence or probation? We can't have it both ways. So I'm actively in the prisons. I know that it boosts people's ability to feel part of And I don't believe that having someone have to ask for those things is advantageous to the time that it takes. And I did work with Governor McDonnell on his reentry, and it was a great encouragement to those that are incarcerated. And so I just hope that you would consider that and accept that as policy.
Madam Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. We've consistently supported measures like this, and we do so again today. This policy is consistent with the policies of the vast majority of states in the country, and it also enables full participation in the political process, which is something that we support. Thank you.
Madam Chair and committee members, Richard Walker, founder, executive director, Bridging the Gap in Virginia. I, too, am a formerly incarcerated convicted felon. I had my rights restored by Bob McDonnell back in 2012. I've been on a mission ever since. I've had the angst of believing that this should have been repealed because it was based on racist constitution back in 1902, you know, where they said this is a means and a ways to keep the darkies out of our government. That alone makes a statement that this should have never existed this long. You know, I appeal to you to push this through for this season, this session, that HJ2 is vital for individuals such as myself coming out of incarceration or not being incarcerated ever, to be able to have their voting rights, to be able to be a public notary, to be able to run for public office, and to be able to do those things that normal individuals have been able to do, that they may feel that they are a citizen of the United States, a citizen of the Commonwealth of Virginia. These individuals know that our forefathers were fought and were bloodied and beaten to have the right to vote. And this adversely affects primarily minority African-American men. And it's high time for this piece of legislation, for this constitutional amendment to go through. Thank you.
Good afternoon. My name is Jerome Legends, and I'm just a citizen of Richmond. And the reason why I'm here is because I've talked to so many of my neighbors, friends, and family members, and I recommend that you support this bill. Thank you.
Hello, Madam Chair, members of the committee. My name is LaTwyla Mathias. I'm the Executive Director of Progress Virginia. We are a member of the Right to Vote Coalition, and we strongly support HJ2. Thank you so much.
Good morning, Madam Chair and members of the committee. I am the Executive Director, Kenda Sentinel of Birth in Color, and we strongly support this bill. We have a large fatherhood initiative, and what the common theme is that they don't understand the process of right to vote, but they are tax-paying citizens and have taken reentry programs. And so I walked them through the process of going to the portal and applying, and this was a year ago, and about 15 of them still have not heard any responses. So I definitely think that this is strongly needed.
Good morning, Madam Chair, members. My name is Rob Hogenclass. I'm Executive Director of Justice Forward Virginia. We don't come to privileges and elections very often, but we're a public defender-led criminal justice reform organization. Felony disenfranchisement is one of the harshest collateral consequences in our criminal legal system, and so we support the amendment. As others have said, it has awful racist origins, and it's time to be rid of it. Thank you.
Good morning, Madam Chair, members of the committee. Sean Wineta, speaking on behalf of myself as a returning citizen today. If I may, Madam Chair, I would echo, of course, the remarks of the people who have spoken before me. I would, if it's possible, to add a little context to some of the questions that came from the dais earlier, particularly about people in jail voting and the restitution side. Right now, people in jail already vote. This constitutional amendment would not change that at all. People that have not been convicted of a felony that are pretrial, which is most people that are in our jails right now, are eligible to vote until they are convicted. So this would not change that at all. Again, also, and to further add to that, after your rights have been restored, and then if you go back to jail again on a new felony arrest, you again have not been convicted, you would still be eligible to vote until a conviction is actually is accomplished or is imposed. So that doesn't change anything that's already happening today and has happened for generations. To the sort of possibility of our jails and prisons being basically violent offenses, and that people don't go to jail for a nonviolent offense. I had a 30-year prison sentence for embezzlement, and I served 16 years of that before being pardoned by Governor Northam. Ms. Williams earlier spoke about 69,045 people that were restored in one day. I was the third person that Governor Northam restored that day. I still have the pen, and I vote in every election, every special, every primary. Until that opportunity, the only way that I could have any impact on the system was by coming here and bugging you and showing up at your offices and sending you emails and text messages. Now I can do that at the ballot box. Most people don't have the opportunity that I have to come here every day. It's the only way they can access it, whether they're in Big Stone Gap, Virginia, or Arlington, or Virginia Beach. They can't come to Richmond every day and influence this process in the way that others of us might. This is their way to have their say. So I do support this and hope you will as well. Thank you.
Madam Chair, members of the committee, Blair St. Ledger Olson with the Virginia League of Conservation Voters. As a member of the Right to Vote Coalition, we support HJ2. Thank you much.
Madam Chairman and members of the committee, my name is Stephen Spitz, and I'm representing resolutions addressing structural and systemic racism, RASAR. And I just want to read something I just read yesterday in Doris Kearns Goodwin's new book. This is from Lyndon Johnson's speech before the Voting Rights Act was passed. Many of the issues of civil rights are very complex and most difficult, but about this there can be and should be no argument. Every American citizen must have an equal right to vote. When you're released from prison and returned to the community, we want people to participate in a legal way instead of re-offending. The best way to ensure that they become full members of society is restoring the right to vote. Thank you.
Thank you, Madam Chair. My name is Michelle Cantor-Cohen. I'm here on behalf of Fair Election Center, and we are a member of the Right to Vote Coalition. We support this amendment. And I will refer to a written comment and just say that a system that gives one person the sole authority to restore voting rights to formerly incarcerated citizens is untenable. Virginians who've successfully served their time should be able to fully rejoin civic life and be given a second chance. Thank you.
Good morning, Madam Chair and members of the committee. My name is Michelle Moffitt. I'm with the Virginia Civic Engagement Table, and we are in full support of this constitutional amendment. Thank you so much.
Good morning, Madam Chair, committee members. My name is Lakeisha Cook, Reverend Lakeisha Cook. I represent Virginia Interfaith Center for Public Policy as the co-executive director. We are also a member of the Right to Vote Coalition, and we are in full support of this amendment. Thank you.
Good morning, Madam Chair, members of the committee. My name is Liz White. I'm the executive director of Upvote Virginia. We are a member of the Right to Vote Coalition and in full support of this amendment. Thank you.
Good morning, Madam Chair, members of the committee. Joan Port, President, League of Women Voters of Virginia. We are also a member of the Right to Vote Committee, and we strongly support this amendment. Thank you.
Good morning, Madam Chair and members of the committee. My name is Chris DeRosa. I'm from Arlington, Virginia, and I'm with the Spread the Vote Project IDEA 501c3 organization. My volunteers and I have worked for over 7 years, voter registration, getting IDs. We talked to hundreds of people, and dozens of them, we showed them that they had gotten their rights restored for 7, 8, they could have been voted for 7, 8, 10, 12 years. They had no idea because of this law. So we need to change that so they can automatically get their rights restored as they return to the community. Thank you.
Madam Chair, Michael Sizemore, Advocacy Manager for the Substance Abuse, Addiction, and Recovery Alliance of Virginia. We fully endorse and support this bill's passage. Thank you.
Good morning. My name is Gus Smith. I'm from Hanover County. I'm here representing my daughter, who's Kimba Smith, who actually served on the state parole board for the state of Virginia, appointed by Governor Northam. And she witnessed a lot of people coming home that could not vote. And I echo the sentiments of the gentleman early. The bill was passed in the early 1900s that would not allow us to vote, people of my color, and it's old Jim Crow law. This is a new day, a new time. We need to move forward. It's really important that this bill passes. Because if I'm a returning citizen, at least I need to have the right to determine who I can vote for, determine where my child will go to school, or where I can buy a house, or what the county restrictions and laws will be. And by not being able to vote, you cannot accommodate those situations. Thank you.
Hello, Madam Chair. Jennifer Strozier. I'm with the Goochland Democratic Committee and the Goochland NAACP. I'm here in support of this amendment. I've yet to hear a valid argument for disenfranchising citizens. It's a racist holdover, and we need to restore the rights of people who have paid their dues. Thank you.
And now if we will reset the clock, anyone who is in person to speak against the proposed constitutional amendment can please come forward.
Hello, I'm Sheila Fury. I'm an election officer for the city of Richmond. My concern about this legislation is our current election process is so flawed, and we are adding more constraints to that system. The fact that we don't have IDs that match the person and where they currently live, that we have 45 days of early voting, which allows a lot of confusion. When we have, as working on the election, we have people who have received absentee ballots who are still marked in the poll books as eligible to vote. There are so many problems with our election process and wanting to have transparency on this process. And all of those issues need to be addressed, as well as this issue. And I think what the two delegates pointed out is for those members who have committed felony crimes and have not done restitution to the victims, that their rights are never lost. If you have been embezzled by hundreds of thousands of dollars and the victims are never repaid that money, and yet the person who perpetrated that crime continues to be allowed to vote, let's think about the victims. Let's think about all of those who are harmed, as well as I have no objections to people having their rights restored, but we also have to think about the victims in this process. Thank you very much.
Thank you for letting me speak. My name is Kristen Holte out of the Hanover County area. I'm speaking on just being a constituent of Virginia. I oppose this amendment because there are enough issues with election integrity as it is. This will cause even more problems, especially dealing with the ID incident, and also, once again, the restitution issue. This is so pro-criminal. What about the victims? The victims need to be thought about in instances too, not the criminal. This society has become so concerned about criminals these days and not about the victims. So I oppose this amendment. Thank you.
Good morning, Madam Chair and members of the committee. I'm Dr. Dennis Petruccelli. I'm speaking on behalf of myself, not my employer. I would oppose this bill. If I cannot trust you with a cartridge box, I cannot trust you at the ballot box. I don't believe that rights could be separated and considered distinctly. Thank you for your time and consideration.
Donna Machin, Foster, Virginia. And I just want to simply say that I share Dr. Fury's concerns, and thank you for listening.
Greg Carroll, North Springfield, Virginia. Ms. Chair and committee members, thank you for this opportunity. The mainstream media has no evidence that young African-American males are being targeted by police and incarceration at a rate inconsistent with their participation in violent crime.
Madam Chair, Pastor Rich Pickens, Virginia Beach, member of City Elders.
I thought Mr. Gilbert had I was listening to the arguments and I thought he had to ask it 3 times, but it finally got the answer. And I think the reason there was a hesitancy in answering a direct question with a direct answer is because that reveals a weakness that I think needs to be examined. And to me, I was with it. I believe that if people have done their time, paid their dues, that there should be a restoration of their rights, because it shouldn't be penalized further. But what I realized was, as a victim myself at times, you want restitution. And if you want people to feel better, it isn't just giving their rights back, it's getting them rights back that they deserve, that they've earned. And if you were doing Old Testament law, which we're not, if you sold 1 sheep, you had to pay back 5. That's a high price, but it put a high price on a serious issue. So I think it's reasonable to request that there isn't just this, we didn't get any penalty, you don't spend any jail time, we did a crime, but we get to go about our business. I think you don't get your rights back at that. I think you have to make things right with the victim. I felt Mr. Gilbert's had sound reasoning, and I felt like the young lady that was speaking, though she had a really good way of presenting it, I think she was trying to skirt the answer to that for a particular reason, and I think the answer is, yes, we want people to have their rights back, but they have to pay back their victims. They'll feel better about themselves. The victims will feel better about themselves, and I think that's a reasonable course of action. Thank you very much.
Thank you to all who have spoken. We are now going to go to online, and we will have 5 minutes for online in favor. So if you are in favor of the legislation, if you will please raise your hand and you will be called on. Let's see, I have Leanne Rates. She's in the room. You can unmute and speak.
Hello, hello, members of the council, Madam Chair. I thank you for allowing me to speak, and I speak in support of this amendment. I think it's important to notice that we are not absolving anyone of their crimes, of their restitution. It's just that rights are unalienable and we shouldn't have to earn them. Restitution may still be paid, and you've listened to all of the research that shows that this reduces reoffending, which reduces victimization. And if you care about victims, supporting this amendment will reduce further victimization. Thank you.
Thank you. Aaron Grady.
Thank you, Madam Chair, and good morning to all members of the committee, staff, and fellow Virginians. My name is Aaron Grady. I'm a lifelong resident of the Commonwealth of Virginia. I'm here in support of all 3 amendments, but on the matter of House Joint Resolution 2 regarding the qualifications of voters, I enthusiastically support this amendment. Those who have been convicted of felonies, serve their sentences, and return to their communities should be supported in as many ways as possible in order to become contributing and successful members of the society. This includes enfranchising them so that their voices are heard and their participation in their communities is encouraged. The automatic restoration of voting rights for those who have paid their debt to society sends the message that they're welcome back to their community and that they are expected to participate in civic life in a productive manner. Thank you.
Matthew Sinclair. John Holland. Ms. Knopfler. Kaylin Weil. Zach Van Schneck. All right, so we will go to those online in opposition, and if we can get a 5-minute clock. First, we have Vic Nichols. Ms. Nichols, if you'll come on camera and unmute.
Sorry, this is slow. The patron has shown 0, much less credible studies that voting alone does all that's claimed here today. The same party members do all they can to restrict guns from law-abiding folks, but have no problem fighting for former criminals because the target group votes for them. This is exactly the attitude and ideology that was massively voted down last Tuesday due to detrimental results. Thank you.
Sheila Fury. Dennis Petroselli, I think he's in. Okay. Jeffrey Fuller? Is there anyone else that wishes to speak in opposition to HJ2 that's in the Zoom? Okay. Coming back to the committee, are there any questions or statements from the committee? Delegate Glass.
Gratitude, Madam Chair. I have a statement. I think the question that we need to ask ourselves, and it's not the folks sitting up at this dailies, because I think there's another question that we should be asking ourselves is, why is the right to vote tied to crime that has nothing to do with voting? It's a fair question. The question that this committee is trying to answer is a felony conviction or incarceration a consequence for a crime? One thing I know, Madam Chair, is that when I get the futzing with my husband, because I nag, and I put him on conversation punishment, as he likes to call it, and I come out of conversation punishment to speak, he assumes that the crime that he has committed against me has passed. The moment that I decide to bring that up, whether it's daily, weekly, when I am triggered, I tell him that he has not paid the consequences, said conversation punishment for that crime. Or transgression, let me say that, transgression. How many more times do you think I have to bring that up to him, Madam Chair, before he says enough? Before he's no longer a contributing member to our marriage? There has to be a way for him to move on. I have to forgive. I will not forget. You see, Virginia is very unique right now, and not in a good way. When it comes to voting rights of formerly incarcerated neighbors, we are one of the 10 states, and I'm going to say that 10 states, this has been said, where rights are lost indefinitely or require a governor's pardon for certain offenses. However, Virginia likes to be unique, she does. And all of our incarcerated neighbors with felonies are permanently banned from voting unless they receive an executive pardon. We are the only state with this blanket restriction, the only one. If we, and I've said in these rooms, if we in this Commonwealth are committed to rights and freedoms, then our formerly incarcerated neighbors deserve a process. That is what we're saying here, a process that is both consistent and transparent. Let me say that again. They deserve a process. We are determining a process that is both consistent and transparent, not at the whims of those who are in the governor's mansion, no matter what their politics are. So we have a chance here to be walking away from second chances and toward fair chances. Our formerly incarcerated neighbors should have a fair opportunity to rejoin and contribute to our democracy. Not only that, our formerly incarcerated neighbors, and I'm saying that because these are your neighbors, you don't know how they would vote, deserve that fair chance to reclaim their place to fully participate, to pursue what we like to call as the American dream, including the right to vote and be president, or be a president that votes for themselves. So let us here, hopefully, collectively, take them off conversation punishment and allow them to have a voice in our community and effort to simply be our neighbors. Thank you, Madam Chair.
Delegate Milday.
Thank you, Madam Chair. As someone with experience in this matter, and I believe I'm the only one up here with direct personal experience, let me offer some observations. I, like thousands of others, a few of which we've heard from, went through a lengthy, deliberative process to regain my rights. That started with completing my court's imposed sentence in its entirety, including paying restitution to the victims and fines, as it should have. For over 20 years now, I've told people that I've had my rights restored, they knew it wasn't automatic or easy in Virginia, but they knew that it was important enough to me for me to take the initiative and make my case for redemption, to regain the trust that I gave up voluntarily. I messed up, and I had to earn this, and that's okay. And thousands of others like me valued our civil rights so much more. We value our regained civil rights so much more because of the process we followed. I was incentivized to be a better member of society because I knew there was a process. I'd reject the argument that it's the other way around. There's a difference between serving your sentence and turning your life around. It's not asking too much to require a person who's gone down the wrong path previously to demonstrate that they've had a genuine change of heart. If you want a second chance, it's not asking too much to require that you ask for that second chance. Obviously, I disagree with some people, regardless of their party, who say once a felon, you should never be able to vote. But the context really matters. Thoughtful consideration in each case after a request from that felon. In many cases, we're talking about violent felons. It just makes sense. I hope we all here believe in redemption and forgiveness. I'd like to think there's a wise, compassionate, and forgiving position that can be reached on this issue. And that's where I stand, but this isn't it. This just goes too far. Thank you, Madam Chair.
Yes, and I will take privilege here to offer my own comments. I think there's been a lot of focus on, as the previous delegate just spoke, on what the process and the weight is for the formerly incarcerated person. But what we have today are formerly incarcerated people who have tried to go through that process. But we have an administration that has an opaque, inconsistent, and I'll stick with opaque and inconsistent process by which no rationale, no reason, just a mass email can go out to say that your rights were denied. And so, however many people in this room or on this dais can say that previous governors have done certain things, that is not where we are today. And the other part that we have not really touched on that I would like for the public to know as well, that the patron has within her bill establishment of a fundamental right to vote. And that impacts all of us in this room, because a lot of us are walking around thinking that that right exists. And if it's not in the Constitution, it doesn't. And so I think that that addresses some of the concerns, but I would love to turn it to our patron for any final comments.
Thank you, Madam Chair. The right to vote is fundamental, and it's time that Virginia affirmed that and eliminated barriers for returning citizens. By restoring voting rights, we're empowering Virginians to have a voice, to fully participate in society, and a voice in shaping their communities. Right now, you can apply for restoration of rights after you're released from incarceration without any further condition. However, the current system, as you just alluded to, is left at the discretion of one person and does not live up to our values of justice. There's no transparency. This amendment creates a process that is transparent, bound by rules and criteria, and will apply equally to everybody. This amendment is about justice, redemption, and reintegration. Thank you.
Delegate Maldonado.
Madam Chair, move to report.
Second.
It's been moved and properly seconded to report House Joint Resolution 2. Is there any discussion? If the clerk will please open the roll and members cast your vote. And that bill passes on a vote of 12-9.
Thank you, Madam Chair.
Delegate Sickles, if you will come down to the dais. Thank you. We will now discuss House Joint Resolution 9, patroned by Delegate Sickles.
Good morning again, Madam Chair, members of the committee. It's great to be here this morning. This resolution is an amendment that declares the right to marry as a vital right and requires the Commonwealth to issue marriage licenses, recognize marriages, and treat all marriages equally under the law, regardless of the sex or gender of the couple. There are a couple of small changes from the version that's been online for over a year, and I'll explain those in a second, but you can see them online now.
So, Mr. Chair, did you have an amendment that you wanted to put properly
Yeah,
before?
if somebody would move it, I'll move it.
Okay, so it's been moved and properly seconded for an amendment to be before us. All those in favor, please say aye.
Aye.
Any opposed? So that now the amendment is before us, and is that online?
Okay, and I will talk about that in just one second. So this repeals a provision defining marriage as only a union between one man and one woman and many other things. So I encourage the citizens of Virginia to read what's in our Constitution right now. It is passé to say the least. The voters enacted this in 2006. We've had 100,000 voters a year to turn of voter age since then, and many people have changed their opinions of this as the years have passed. I'm asking to put this before the voters 20 years after it was enacted to see where we stand on it now. I feel sure that it will be repealed. The current language is not valid because of the United States Supreme Court decision in Obergefell versus Hodges, a 2015 decision. And the court ruled that the 14th Amendment requires states to license and recognize same-sex marriage. So the changes from the version that has been online are relatively minor, removes the phrase, fundamental right inherent in the liberty of persons in marriage is one of, from lines 21 to 22. This is implied in its inclusion in the Constitution and is unnecessary. Secondly, it replaces the phrase two parties contemplating with two adult persons seeking to ensure marriage is limited to two humans of marriage age. Adult marriage is described in the code and was amended in 2004 to raise the age to 18. And it removes the explicit right of refusal by clergy to perform a marriage. That was protected by the First Amendment all the way along, but we explicitly fixed that in the code this past wintertime with a bill, with legislation. So I think this is pretty simple. I will read what's left. It's 3 sentences. That marriage is one of the vital personal rights essential to the orderly pursuit of happiness. This Commonwealth and its political subdivisions shall not deny the issuance of marriage license to two adult persons seeking a lawful marriage on the basis of the sex, gender, or race of such persons. This Commonwealth and its political subdivisions shall recognize any lawful marriage between two adult persons and treat such marriages equally under the law, regardless of the race, gender, or race of the persons. And that's the amendment, Madam Chair.
Thank you. Are there any questions? Delegate Gilbert.
Thank you, Madam Chair. I apologize, and maybe I just don't have my session level technology chops going, but we're about to make a change to the Constitution. Where can I look at the amendment that the delegate just had adopted?
My understanding, Delegate Gilbert, Madam Chair, that it's online.
Mr. Attorney?
Madam Chair, Delegate, if you go to the search bar on LIS and type in HJ9, it'll bring you to the bill. Gotcha. And then under bill versions, the introduced for the privileges and elections substitute offered.
Okay.
The first one
so
on top.
I don't need the IHOD app to do it. Perfect. Thank you, Madam Chair. Thank you, sir.
And we thank our clerk again for this beautiful new website. Are there any questions from the dais? Delegate Bloxham.
Thank you, Madam Chair. Just want to clarify. I think he was talking about the religious exemption covered somewhere else, but I was trying to read the substitute. Could you explain that again for me?
The provision that we had last year, lawyers and commenters decided it was not necessary to put in here. We have it in the code now. We passed a code provision that the governor signed last year, but also we never really needed it anyway. This is a right granted under the First Amendment of the Constitution, freedom of association, and no minister has ever been forced to officiate a wedding they did not want to officiate.
Okay, under the First Amendment in the Constitution.
Yes, sir.
Madam Chair, thank you.
Any other questions from the dais? Okay, we will go to public comment. If you are in the room to speak in favor of this amendment, if you will please raise your hand. If you are in the room to speak against. Okay, if we will please set the clock for 10 minutes. And for those that want to speak in favor, if you'll please come down, state your name, and be mindful of the others as you're speaking.
Still morning, Chair Price and members of the committee. My name is Norissa Rahman, and I'm the Executive Director of Equality Virginia, the statewide LGBTQ advocacy organization. While I'm proud to hold that role, the role I am most proud of is being a wife. I'm here in unwavering support of HJ 9 and marriages like mine. Funny enough, today is our 6th anniversary. 6 years ago today, my wife asked me if I would officially go steady with her. And since then, we've celebrated many other anniversaries and special moments. Our first house, our first Christmas, the days we adopted our dogs, and the day we got married. There are roughly 20,000 married same-sex couples in Virginia, and that's nearly 20,000 special days, Christmases, anniversaries, and tens of thousands of people, the couples themselves, but also their friends and family members, whose lives have been changed by the availability of this basic, fundamental, joyous right. Now, there are folks here in this room who don't yet believe in the joyous right of marriage equality, but when I look at their marriage and the marriages of those 20,000 couples, including mine, I see more similarities than differences. We've all experienced special days and anniversaries that not only make a marriage, but also make a lifetime. Here in Virginia, we've seen how our state has evolved in its thinking about same-sex couples and LGBTQ people overall. Almost 5 years ago, this very General Assembly passed strong, inclusive, non-discrimination protections for LGBTQ people. And just this year, Governor Glenn Youngkin signed a measure that took a big step in removing marriage discrimination from Virginia's laws. And now it's time for our state to fully complete our evolution and finish the job on protecting marriage equality for all. It's up to all of us to safeguard marriage and push for a constitutional amendment guaranteeing the right to marry for all Virginians. Should the Supreme Court precedent ever come back up in the future of the court, we will know that we have done everything we can to protect marriage in Virginia. There are so many in this room who are here because we believe in freedom, not just for ourselves, but our neighbors. And it's time the Constitution affirms, not limits, those freedoms. So today, with all the love I hold for our Commonwealth, for those who call it home, and for those who may want to one day marry, I urge you to pass HJ 9. And happy anniversary, Brianna.
Happy anniversary.
I'm Brianna, I'm that wife. So hi. Thanks for surprising me. Good morning, Madam Chair and members of the committee. My name is Brianna Diaz, and I serve as Policy and Legislative Counsel for the ACLU of Virginia, and we proudly support this resolution. I echo my wife, who spoke before me, that no law, court decision, constitutional amendment, or shade ever made anybody less gay. But the lack of explicit recognition in law sends a message to LGBTQ Virginians that who we love is something to be ashamed of or condemned, and everyone deserves to marry the person they love, and our Commonwealth's Constitution should reflect that. Oh God, okay. There are a handful of defining moments in my life, and one of those moments was the day I married my wife right here in Virginia. As we discussed when to file for our license and get married, the question at the forefront of every planning conversation was, should we get married as soon as possible in the event we lose the right to marriage? Y'all, I just wanted to plan my flowers and get a nice dress, but that was the question I had to ask. No one should ever feel such urgency, uncertainty, and fear when planning their wedding. But HJ9 seeks to alleviate that uncertainty. And so we thank the patron for bringing the resolution, and I humbly ask you all to support it. Thank you.
Hello, Madam Chair, members of the committee. My name is LaTwyla Mathias. I'm the Executive Director of Progress Virginia, and we strongly support HJ9, and I'd like to say happy anniversary to Brianna and Narissa.
Hello, Jennifer Strozier Goochland. Last year, October 7th, my daughter married her wonderful wife. They're currently living in Louisiana. Losing that right to marry loses all of her protections and the protections they have toward one another. There's no reason other than some archaic religious ones for people of the same sex not to marry. It's about time we get on board with this. Thank you. I'm in favor of this resolution.
Hello, Madam Chair and committee members. My name is Samira. I am a doula with Birth in Color, and we are in full support of HJ9. Thank you.
Hi, good morning. Rena Hicks, Co-Executive Director of Freedom Virginia. We strongly support the freedom to marry who you want. Thank you.
Hello, Madam Chair and the committee. Thank you for having us today. My name is Pat Evers. I'm a member of the League of Women Voters of Virginia. The issue of marriage equality is very important to me because I have a 34-year-old daughter who's in a long-term, loving relationship with her female partner, who we've also come to love and know. It disturbed me greatly to see that in 2022, the Republican-controlled House of Delegates rejected a proposed constitutional amendment to repeal the constitutional ban on same-sex marriage, despite popular public support. This ban does not reflect the attitudes and beliefs of Virginians in 2024. Polling suggests that a majority of Virginians support the legal recognition of same-sex marriage. And a 2021 survey conducted by the Public Religion Research Institute showed that 71% of Virginians supported same-sex marriage. And this percentage has only increased since the question began being asked of voters. If you consider that in 2006, 53% of voters supported the marriage ban. So this huge swing between 2006 and 2021 shows the massive shift in public opinion on the issue of marriage. And it's clear that this antiquated ban should no longer be a part of Virginia's Constitution. So it's only fair to revisit a political question that has shown such a big change since it was first broached. Because women's protections were removed, sadly, with the destruction of Roe v. Wade, it's totally possible that marriage equality will also be destroyed on a national level. So we really need to do the right thing in Virginia and take the lead to protect all citizens. Thank you for your time today.
Hi, my name is Sydney Mago, and I am just a mom of an LGBTQ daughter and a straight son. And both of my children deserve the right to be happy and marry who they want. And that's it. So please support this bill. Thank you for this amendment.
Good morning again. Michelle Moffitt, Virginia Civic Engagement Table, in full support of this bill. Thank you so much.
I'm Gail Christie, representing the Justice and Witness Action Network, Virginia, of the United Church of Christ. The United Church of Christ affirms equal marriage rights for couples regardless of gender and declares that the government should not interfere with couples regardless of gender who choose to marry and share fully and equally in the rights, responsibilities, and commitment of legally recognized marriage. We support this amendment.
Good afternoon, Madam Chair and honored delegates. I'm Stephen Kano. I'm a U.S. Army veteran and a retired firefighter. I'm the father of a gunnery sergeant who serves in the U.S. Marine Corps, protecting our freedom. I'm also a proud husband to Jeff, who I married in 2021 here in Richmond. I'm here in support of House Joint Resolution 9. I work to make our city and state a better place to live, but right now, our state constitution doesn't recognize my marriage. My firefighter brothers had my back in fires we fought. I'm asking that you have ours in favor of this amendment. I'd like to protect the commitment my husband and I made to each other when we married in August 2021. And I encourage you to pass House Joint Resolution 9 and affirm our freedom to marry. And I thank you for your time in this day.
And we will now reset the clock and have any that wish to speak in opposition to HJ 9 come forward at this time. Please identify yourself as you're speaking and be mindful of others behind you.
Good morning again, Madam Chair and members of the committee. Dr. Dennis Petrocelli. I'd ask that you oppose this measure. If the First Amendment was as clear as the patron suggests, there would be no buffer zones. There would be no such thing as misdis, malinformation, censorship. I would request that any consideration of this bill explicitly include protection for the conscience of religious persons. Thank you.
Thank you, Madam Chairwoman, members of the P&E Committee. I'm Todd Gackey, speaking on behalf of the Family Foundation in opposition to HJ 9. I'll begin by stating that marriage exists to bring man and woman, a man and a woman who are different and complementary, together as husband and wife, to be a father and a mother to any children that they may have together. It's a fundamental building block for all of human civilization. And regarding the actual language of the bill, here's some problematic components. First, marriage still remains undefined in the code. Second, for the first time in Virginia's Constitution, sex and gender would be separated as two distinct categories. This would enshrine the concepts of gender identity or transgenderism into the Constitution. This language could then be used to elevate gender to protect its status in other contexts. This means this language, if approved and added to the Constitution, could be used to block Virginia from ever passing a law to keep males from competing in female sports or allowing males into female bathrooms and changing facilities. This bill is not just about redefining marriage, it's about elevating gender ideology to a special protected class in the state constitution. So for these reasons, and to uphold the time-honored institution of one man and one woman marriage, we strongly oppose this bill. Thank you.
Madam Chair, members of the committee, we appreciate your service to our Commonwealth. My name is Dr. Michael Huffman, and I'm the Executive Director with the Virginia Assembly of Independent Baptists, and I represent over 500 plus Baptist churches scattered throughout the Commonwealth of Virginia, and we stand in opposition of HJ 9. The bill seeks to fundamentally change the Commonwealth's Constitution to allow for marriage between the persons of the same sex because of a Supreme Court decision 5-4 in 2015. The Equal Protection Clause of the 14th Amendment of the United States mandates that no state shall, quote, deny any person within its jurisdiction the equal protection of the laws, end quote. But the 14th Amendment that was ratified in 1868 did not have marriage in mind. What it had in mind and what the framers' original intent was the protection of the rights of recently freed slaves. The historical context of that original intent, therefore, does not explicitly encompass the provisions of marital rights. In Loving versus Virginia in 1967, the court struck down laws prohibiting interracial marriage based on racial discrimination. So while it upheld marriage as a fundamental right in the EPC, it did so in the context of racial discrimination. The U.S. Supreme Court in 2015 never had the right to make the inclusion of same-sex marriage as a national mandate. This party-divided decision of those 5 justices was unconstitutional because the 10th Amendment of our Constitution does not allow it. Under the Equal Protection Clause, if we were to grant marriage as a fundamental right, then what would cause in the future for us to open up laws for polygamous marriages or incestuous marriages? This law creates a vacuum and a hole that I think that the standards and the conditions of the Commonwealth will not, and the principles of the Commonwealth will not allow. Thank you very much.
Madam Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. We supported the ballot initiative in 2006, specifying that marriage is the union of one man and one woman, and we've consistently opposed measures such as this. that seek to undo that, and we do so here again today. We affirm the dignity of every person. We also affirm that marriage has an original design and purpose. And that original design and purpose predates any nation, any religion, and any law. And we urge you to uphold that principle here today. Thank you.
Madam Chair and delegates, my name is John Godfrey. I'm pastor of Great Hope Baptist Church in Chesapeake, Virginia, also a member of Faith Winds, Virginia. God invented marriage. He determined it was between one biological man named Adam and one biological woman named Eve. And to redefine that is gross hubris. Thank you. We oppose this.
Dear Privileges and Elections Chair and Committee, my name is Donna Machin, and I live in Matthews County, Virginia, and I have lived in Virginia all my life. The bumper sticker on the back of my car says, Virginians for life, and I pray that will not change. I am strongly opposed to HJ1 and HJ9 because they mean death to the Judeo-Christian values Christians like me hold dear. HJ1, so-called reproductive freedom, is a false promise because real freedom is found in loving and protecting the unborn God has entrusted to us. HJ9,
This is warning one. Excuse me. I would ask that you keep your comments to HJ9 only at this time. Thank you.
Because only a marriage between a man and a woman for life is designed to protect a truly healthy, happy home. Our beloved slogan is Virginia is for lovers. Real love is striving to love God, each other, and our children. My prayer is that the laws in Virginia that are opposed to the protections in the Virginia Constitution of life and real love will be restored. I urge you to use your time wisely to create legislation to that end and kill HJ1 and HJ9. Thank you.
I address the Madam Chair and the committee. I agree with everything that was said by the ones that were just up here. And also, the family is the basis of society. And if we want to have a healthy society, we have to have healthy families. And in HJ9, is it that putting together two of one sex is not marriage? They can be friends, they can love each other the way they want. But to put marriage on it is not a good idea. And it's not a good idea for the state of Virginia. Thank you.
Thank you, Madam Chairwoman and committee members. Thank you so much for your time and dedication to our state. First of all, I just want to say that this is my first time here, so I'm really excited just to say thank you. My name is Melissa Calder. I am a mom, and I'm a mom of 4 kids, and I'm strongly opposed to this amendment. Marriage is a sacred institution between one man and one woman. It's given by God. It's not archaic. Our God is alive today, whether we choose to acknowledge that or not. He is alive and he is well, and he sees all the decisions that we make today. And the current language of this amendment concerns me because parties is problematic. I've agreed with everything that's been said, of course, already, but I just wanted to say this one more thing. The language of parties is problematic. It hasn't included that it's only between 2 people. We need to include that. It should say between one man and one woman, but let's be extra clear. Even if you're going to continue with the current language, can you please keep it to parties of 2 people? Because you did change it. Oh, thank you. I appreciate that. Thank you for your time.
Thank you for letting me speak again. I oppose HJ9 because I feel like it opens the door to other problematic issues, such as biological men participating in women's sports, taking away the woman's right to participate in women's sports, which takes away from her financially, scholarshiply. I am against men participating in women's sports or going in women's bathrooms. I feel like this bill would be problematic in the future. And once again, I'm going to state, Jesus is Lord.
Madam Chair, Pastor Rich Pickens, Virginia Beach, representing New Day Church and city elders. Mr. Sickles, when you were presenting your case, I think you made it sound so sweet, so simple. And I do respect everyone who's been here on both sides, and I've tried to convey that at all places. If you have a flat tire, I don't care who you are and what you believe, you're going to have my help. And I think that's the way everybody should treat everyone. Having said that, I look up here at this constitutional amendment. That's a big deal, putting it in the Constitution. And I look at the word marriage specifically, and I've always had an interest in this because I think we're playing with the language in a way that isn't, it might be convenient to some, but it's not legitimate. Marriage is a biblical word. It always has been a biblical word. In fact, Jesus himself said, define marriage. He said this the way it's always been from the beginning. That word marriage comes from a biblical context, and it specifically means, without any need for more clarification, and marriage is a union, a physical union between a man and a woman.
Thank you so much for your comments. We're actually out of time.
Well, I want to just finish this one thought.
No, that's not how this works. Excuse me. Excuse me, sir. Excuse me. I don't want to have to call the warning. This meeting will be at ease. The committee is at ease. Seeing none, Delegate Sickles, would you like the last word?
Sweet and simple person. I'll just start out there. That is my goal, and I think this is sweet and simple language, and you know, we have to have a difference between
Delegate Sickles, I'm so sorry. I forgot the online testimony, so if you could give me a sweet and simple second, we will have the online testimony. Thank you so much to staff for catching that. So if you are in the room and you are speaking in the Zoom room and you are speaking in favor of HJ9, if you will please raise your hand. And then if possible, if I could ask our clerk to call the name since she can see, and we'll set the timer for 5 minutes.
Thank you, Madam Chair. Leanne Rice.
Good afternoon. Thank you for allowing me to speak. The first point I'd like to make is that Virginia is not a strictly heterosexual or strictly religious state. Therefore, our laws cannot be made for strictly heterosexual people or strictly religious people. To the point of another person in opposition, Virginia is for lovers, and there are no conditions on that. It doesn't say Virginia is for heterosexual lovers or religious lovers only. And if we are to abide by that slogan and be a truly free state, we have to be inclusive to everybody, because that freedom is not exclusive to a specific group of people, or it's not freedom. And my final point is, if you don't want to be queer, you don't have to be. If you do not want to get married to somebody of the same gender, you don't have to. If you don't want to perform it, you don't have to. And lastly, any concerns of what marriage equality opens the door to, quote unquote, are simply not relevant to the current agenda and do nothing but distract at this time. So I just want to close out by saying I fully support HJ9. Thank you.
Alex Sprague.
That's Sprague. Sorry.
My apologies.
Yes, it's okay. I do want people to understand that there are people out there that, like heterosexual couples, would wish to marry the love of our lives. And as a non-binary, yes, we exist. Thank you very much. If you think otherwise, you clearly haven't gotten to know us. And just for the record, we are not infringing anyone's freedom of religion. Just like Leanne said, if you don't want to marry someone of the same gender because of your religion, cool. But we would like our rights not to be infringed either. That's our point. And by the way, what does this have to do with sports? Come on. Thank you very much.
Aaron Grady.
Once again, thank you, Madam Chair. I'm here on behalf of myself as a citizen of the Commonwealth, as a woman in a mixed-race relationship, and the sister of a married gay man. In 2004, as a 17-year-old high school senior, I wrote a letter to the editor about same-sex marriage, specifically in response to an opinion piece published by a former member of this body. In that article, I urged the former delegate to realize that people who were coming of age at the time were largely in support of same-sex marriage. I said the voices of the minority at the time would grow and be heard. In the spring of 2015, as a 28-year-old woman, I excused myself to the bathroom in my office to cry in joy when gay marriage was legalized across the nation through the Supreme Court decision of Obergefell versus Hodges. My sister and I toasted on the steps of the Supreme Court that afternoon. As a 38-year-old woman today, I'm proud that Virginia codified marriage equality through HB 174 during last year's General Assembly session. I will be proud to exercise my right to marry regardless of race when I wed my fiance in the near future. To truly protect this right from future repeal, and to be sure that Virginia is no longer synonymous with anti-miscegenation laws and other discriminatory practices, I enthusiastically support HJ9. Thank you.
Kaylin Vile.
Hi, thank you for letting me speak. I'm here as a constituent of Richmond, Virginia, and also as somebody who deeply loves Jesus and people. And I serve alongside people who are married to the same sex at my church. And I do not think that there is any moral question as to whether or not people should be getting married and if they love each other, because I've seen more love in same-sex marriages than I see in heterosexual marriages. So I am fully in support of this bill.
Thank you. And if you are in the room to speak against House Joint Resolution 9, if you will please raise your hand and the clerk will call on you. And if we could reset the clock. Thank you.
Bob Marshall. Please turn on your camera.
Mr. Marshall, if you could unmute and come on camera, then you can start your testimony. Oh, excuse me.
It's okay. We don't want to.
Okay, we'll go to the next person.
Hannah Nyart.
Yes, thank you. Marriage isn't a man-made institution. It was instituted by God. It was his idea, his creation. He only has the right to define it, and it's clearly defined as one man and one woman. And so it needs to stay that way. And to what people have said in favor of this amendment is statistically untrue, that homosexual marriages are just the same and just as happy. Statistics would prove you wrong in that. But regardless, we can't violate God's law. He didn't give us permission to do that. Marriage is between one man and one woman. Thank you.
Shelley Arnaldi.
Yes, hello. My name is Shelley Arnoldi. I live in Fairfax County, Virginia. I actually tried to speak to the last amendment, but was turned off. So I know I'm not allowed to speak about all of them. I do have one point about all three of these amendments, is that I'm a citizen. I'm not part of a group, and I'm fortunate even to know that this is happening. And it's very concerning that you guys are passing amendments without getting input from the 8 million Virginians, and you have a few small interest groups that are creating these amendments, and the few groups are coming to speak to you. It just seems like you guys are not getting enough input from everyone in Virginia. But to speak to this amendment, I am against it, of course, because I don't think it's been properly discussed. I don't want to discriminate against anyone. I'm not concerned. Gay marriage, not gay marriage, but putting this into a constitutional amendment without vetting it through everybody in the state seems like it's very inappropriate. And I hope to speak to the next one as well, but these three amendments have not been discussed with constituents, and I think it's completely inappropriate to pass these amendments.
Bob Marshall. Unmute yourself, Mr. Marshall.
Delegate Marshall, you are on mute. We have not heard anything you've said thus far. You're still on mute, sir. Yep, still on mute. Delegate Marshall, can you hear us? Can you hear me? Can you shake your head if you can hear me? Okay, we can't hear you, and we haven't heard anything you've said thus far. If you could press unmute. Okay, so while we figure that out with you, we're going to go to the next person, but we will come back to you should time allow.
Christina Williams.
Good morning. Thank you so much for hearing this remote comment. I was a little concerned because I was looking online even this morning. I'm not sure when the online version was changed, but what was presented by Delegate Stickles wasn't the same as what I'd read. But so two things about that. I'm glad that it was changed to say adults, but I am discouraged to hear that there's no protections for our religious. I believe that those protections still need to be specifically stated in any type of constitutional amendment. Then I'd like to say that marriage by natural law has always existed between one man and one woman. There can be no denial of the biological genders that exist from birth. It's coded in our DNA. Marriage is a natural event in which a man and a woman seek to share a life together, to live in unity, and for the purpose of procreation. This is the foundation of society. People will go out of existence if we did not have this natural marriage. And so I would like to say that regarding the affirmative right to marry, all Virginians already have the right to marry and are able to exercise that right freely. I think that the question has become redefining what marriage is. We should not redefine what marriage is, because marriage is between one man and one woman. So desires of the human body cannot negate natural law. We can't change our biology. We have the gift of reason. We can by reason determine that marriage should rightly be only between one man and one woman. because that's the means by which humankind will continue. Through that unity and procreation that are a gift of the bond of marriage. It is the desires of men that seek to redefine the natural law, that law hardwired into every human being, of the knowledge of right and wrong. Just because someone wants something does not mean it is good for them or should be legal. Just laws are those that align with the natural law. That is the light of understanding that exists deep within every human being, through which we know what we must do and what we must avoid. Thank you for the opportunity to speak.
Thank you. So we have 6 seconds left. So Ms. Nichols and Delegate Marshall, if you would like to state your name and state your opposition, we are still going to go with the 6 seconds left.
The no religious protections for any religious freedom, including Muslims, is a non-go. Thank you.
Delegate Marshall, we will register your opposition as such, but you are still on mute. Okay, if you could submit your written comment, then we will have a chance to read it. Thank you. Delegate Sickles, we will come back to you. Oh, excuse me. Delegate Cole. Delegate Sickles.
Well, Madam Chair and members of the committee, it's been 10 years now that we've had legal same-sex marriage in Virginia and in the country. I think people can look around and see, that people are happy now, and they don't want to go back. And you can find out just by voting for this thing, and we'll put it on the ballot. That's what we're going to do. We're going to vote on this thing and see if people have changed their minds since 2006. My guess is they have. People here in this audience are afraid of that. We're very afraid of it. But I say we should do it because the civil rights of people are at stake here. This is a civil marriage. This is that we're talking about here. People can live their own religious life. We have a First Amendment that protects religious freedom completely. And now we have a statute in Virginia that protects the clergy. We just passed that. So I think we're ready to go. And I appreciate everybody's support. Thank you.
Thank you. Delegate Cole.
Thank you, Madam Chair. Speaking to the bill, I have a motion and then I want to speak to the motion. I think it's very clear. We've heard so many different people share their views, opposing and supporting views. But I also want to be clear, Christ was very key when he said that my kingdom is not of this world. The Apostle Paul comes along and says that we are ambassadors to Christ. And so we have to make sure that if you are concerned about the laws of this land, fringing upon your religious rights, keep in mind, you are not of this world and you are just journeying through it. Furthermore, allow me to quote the Apostle Paul in 1 Thessalonians 4:11 through 12. If you're so concerned about your neighbor's marriages, the Apostle Paul admonishes you to make it your ambition to live a quiet life, mind your business, and work with your hands, just as we have told you to. And so with that, Madam Chair, I move that we report.
Second.
It's been moved and properly seconded.
Madam Chair.
With substitute is the motion that I heard. Delegate Bloxham, are you speaking to the motion?
Just to make sure we're voting on the substitute.
Yes, thank you. So this is a motion to report as substituted. It has been moved and properly seconded that we report the substitute for House Joint Resolution 9. If the clerk will please open the rolls and members cast your votes. And that motion passes on a vote of 16-5. And we can close the rolls. Delegate Herring, we will now turn to House Joint Resolution 1. You have the floor.
Thank you, Madam Chair. There is a substitute, Madam Chair. Yes.
Can I get a motion on the substitute?
Second.
It's been moved and properly seconded for the substitute. All those in favor say aye. Any opposed?
Madam Chair, I'm certainly happy to wait. It happens to me all the time.
Procedure on all of our other Other committees? The yeas have it. It is now properly before us, and it is being distributed. If you'll give us 1 second, Delegate.
Yes, thank you, Madam Chair.
And as the members are receiving it for the viewing public, it is also online on LIS. Delegate Herring, you have the floor.
Thank you, Madam Chair. If I got one. Yeah, I don't know where to put it. I know. Thank you, Madam Chair. And good morning still, or good afternoon, Madam Chair and members of the committee. This amendment and the substitute is intended to protect Virginia's reproductive freedom. In a post-Dobbs world, federal law is unclear on reproductive health. It is left to the states to answer. To that end, ensuring fair access to reproductive health care and largely leaving the issues between a woman and her doctor is where what this conversation is about, where health care should begin and end. Madam Chair, what I would like to do is walk through the constitutional amendment, and so I will do that now. You will see on lines 17 through 19, it does provide for a fundamental right to reproductive freedom, including the ability to make and carry out an individual's own decisions relating to prenatal care, childbirth, postpartum care, contraception, abortion care, miscarriage management, and fertility care. Lines 17 through 19, it provides that the provision is offered to protect the continuum of care related to reproductive freedom and health. Lines 20 through 21 is the language that there should not be, this individual right shall not be denied unless justified by compelling state interests achieved by the least restrictive means. Lines 22 through 26 specifies that the state may regulate abortion in the third trimester, but may not restrict abortion where it is medically indicated to protect the life, physical or mental health of the pregnant individual or the fetus is not viable in keeping with current law. Lines 27 through 28 is the non-discrimination provision. 29 through 34 provides protections for individuals who exercise their right and for those who assist them, like doctors. Lines 35 through 38 does define the compelling state interests, and line 30 through 40 is a self-execution clause. Should it be challenged, and a provision is fine, unconstitutional. Madam Chair, this has been drafted with the assistance of counsel, DLS, and that is the substitute amendment.
Thank you. Are there any questions from the dais? Delegate Cherry.
Madam Chair, with the rushed nature of this, I would request if we could have a 30-minute recess for us to review this, take a look at it, and digest what we've just been handed, which seems very haphazard in terms of a change to the Constitution of Virginia, and be handed it and asked to undertake testimony without a proper review.
Madam Chair, I know you will respond to the request, but I have to say, this is not a haphazard approach. I want you all to know that in 2023, when we debated the constitutional amendment that I had filed, I listened to every one of you on your side of the aisle. That's why you have a substitute before you. I took time and care. So I understand the political need to say haphazard. I'm sure I'll see it in a press release later. But this was carefully crafted to make sure we are protecting the law that we have in Virginia. Thank you, Madam Chair.
Thank you, and I will grant you 5 minutes. I know you to be a quick reader, so the committee will be at ease for 5 minutes. We are calling this meeting back to order. Where's my attorney? So before we begin, I just would like to reiterate that these conversations have been going on for years. And so we are very glad to hear from all of the emails, the phone calls, the in-person testimony, the written testimony from, I know we've gotten emails from all across the Commonwealth. So we are glad that everyone is here, glad that everyone is watching. This is a continuation from January legislative session and a continuation from previous attempts to protect the rights that are outlined in House Joint Resolution 1, as was with the other resolutions. These have been ongoing fights for years. So we are going to continue the conversation. I know, Delegate Herring, you said one of your witnesses is having to get back to patients. So if there are any medically related questions, please let us know so that we can get those ahead. And then if not, we will let the doctor get back to their patients. As of right now, I only have one question, so I'll call on Delegate Gilbert.
Thank you, Madam Chair. I just want to say to my friend, I want to rephrase all of that and just ask her to at least acknowledge that this is one of the most heavily litigated types of legal issues that one can imagine. We are literally dealing with life and death issues here. So I think the concern that was expressed in the terminology that was used is that despite the fact that I'm sure the patron has worked on this very hard and that other people have worked on it very hard, getting this right, and I don't even necessarily know what is trying to be achieved, and maybe I should just sit back and let you talk some more, but I am concerned, number one, that this is being rushed. I was concerned that it was being rushed before. Now with a substitute being dropped on us, we are all legitimately concerned that something so important and so open to litigation and various interpretations is being laid before us, and we are given literally 5 minutes to try and put our heads together, not being experts about any of this. I'm sure there are people on both sides of this issue in the audience today who are experts who would appreciate having 5 days, 5 months to look at it. 5 minutes, I appreciate the 5 minutes, but 5 minutes is certainly not enough time to look at something so complicated, but just on the face of it, and I'm just going to ask the delegate. So I heard a reference to codifying or embodying in the Constitution existing state law, but respectfully, I don't think this does that at all, and it definitely turns the compelling state interest from Roe v. Wade on its head. The compelling state interest in Roe v. Wade had to do with protecting a viable child once it was determined that that child was viable. And I will add that this amendment doesn't focus on viability at all. It does have a third trimester reference, I believe, here, but it doesn't. The viability aspect is missing. But even though Roe dealt with viability in terms of compelling state interest, this appears to make passing reference to compelling state interest, not burdening an individual's right to reproductive freedom, which I will also add is not defined. But then when it goes on to define compelling state interest, instead of having that applied to the unborn child, it applies to the individual seeking care, which is where I believe it turns it on its head. So I know that was a lot, but this is a lot. And so I'm just asking the delegate to try to tell us what she believes this actually does in that regard.
Madam Chair, and I appreciate my friend's comments, but totally disagree. So, and I'll run through everything that I have noted that he asked about. So, I'm sorry that some may feel that it's rushed, but this is urgent, and it is not rushed. What we have seen across the nation is women dying or close to death. That's all right. That's all right. We all have our opinions, and I'm a big girl. I will point to Texas, where a woman died because it was unclear in the law whether doctors can complete the miscarriage, and sepsis set in to her body, and she died. What we are trying to achieve here is protection. I will note to the delegate, Madam Chair, that if he compares this amendment to our current code, it protects everything in there, including, I think, Madam Chair, what most people are concerned about is third trimester abortions. We taught the amendment refers to the judgment of the physician about whether a fetus is not viable. It will allow a physician, if the fetus is not viable, to terminate a pregnancy so sepsis or any other thing won't happen, and so that a woman can survive. Madam Chair, I will also point that Roman numeral I on line 23, small I, is consistent with our code of Virginia that talks about whether or not an abortion is medically indicated to protect the physical and mental health. So, Madam Chair, viability is protected if a fetus is viable. But what's important, Madam Chair, is that we do not pass laws in this legislature, which we have seen over and over again, that would interfere with the medical practice. Madam Chair, they may think it's urgent, and it is. We have in Virginia OBGYN deserts. We have practitioners that are not practicing anymore because we as politicians have decided we're going to determine how to treat a patient, and we're not even in the room with them. We don't do that with cancer. We don't do that with many, many physical ailments or conditions. Pregnancy has threatened the life of some women. Some women are lucky and have healthy pregnancies and are able to bring their fetus to term and deliver without any complications. This was brought to protect those women who are not in that situation, Madam Chair. The purpose of this, again, is to protect women and doctors who are practicing. It is not us for politicians to decide at that moment what to do. We are not seeing the patient presented. Madam Chair, we do have things in the code that we have a trimester framework. This amendment protects that trimester framework. Madam Chair, I think the delegate mentioned that it turns Roe on its head, and of course, I certainly disagree. I recognize the concepts of Roe, and Roe had a trimester framework. This amendment recognizes that trimester framework.
Thank you. Delegate Scott.
Thank you, Madam Chair. Just a question for the chair, particularly. I only on my third year here in the General Assembly, and I just want to make sure I understand the process here for constitutional amendments, because maybe I'm missing something. The patron said that this is an urgent matter that we need to decide on right now, but this still has to be voted on before the House twice and the Senate twice. So this is still at least 2 years out before it goes on a ballot. So what would be the harm in having a few extra days or weeks for this committee to really hash this out, to understand that? Because it's not like our vote today is going to change something tomorrow. So that's, again, a question for the chair.
Yes, I appreciate your question. We are finishing and completing the business that we began in January. When this particular resolution was carried over, we have a November 18th deadline. So we are here to do our business and to meet that deadline. Then you will have, as with any other piece of legislation, an opportunity to offer your input on the floor when we get here in January.
Follow-up question, Madam Chair?
Sure.
So what would be the detriment of maybe this being reintroduced in 2025 as regular legislation in the 2025 session, as outlined in the Constitution, where these constitutional amendments are introduced on the election year, and then they are reintroduced the following year? So new language here today that we're given 5 minutes to look at. Now we all have that, and then the patron could submit it for regular session, start in 2025, and then it could go through that regular process at that time. What would be the detriment if that were to happen?
Yeah, I appreciate the question, but the question is out of order. We are here today. We are hearing the bill at the chair's request that we are here today and take that vote. And so we are going to do that. So if there are any other questions about the matter that is in front of us, Delegate Gilbert.
Thank you, Madam Chair. I want to follow up on the parts that I believe to be in conflict. So lines 20 and 21 define reproductive freedom, saying that that shall not be burdened unless justified by a compelling state interest. So it would appear there that the individual seeking care would be the one who would be burdened by the compelling state interest. Then on the definition of a compelling state interest, lines 35 through 38, rather than being burdened by the compelling state interest, it appears that the individual seeking care is the one benefited by the compelling state interest. So how can those two things be inherently in conflict and incompatible, and that make any sense to whoever might review this later, again, for matters of life and death? I don't think the individual seeking care can be both burdened and benefited by the compelling state interest language, and it's the compelling state interest language that I submit to the patron is what she is turning on its head in terms of Roe. Compelling state interest in Roe had to do with protecting a viable child in the womb, not with protecting the individual seeking care. So it makes sense in a Roe context when you're talking about lines 20 and 21, but then when you say that that individual is likewise being benefited by that same definition and no one else, again, it strikes me as inherently inconsistent. And Madam Chair, just for what it's worth, I mean, not one word of this can change once it's decided what the language is going to be. There is no, I mean, they're starting over years from now, but for what the majority is trying to achieve here, you've got to get this right from the start. And if this is going to go through on the second, third day of session, like, now's the time to work on it. We're going to disagree with you about this, but I think you have to get it right. And I think inherently, Madam Chair, it's internally in conflict at the very least. And that was what I was talking about.
Madam Chair, I simply disagree. So I disagree. And as the delegate said, I mean, this is a process. So I disagree.
Are there any other questions? If you are here to speak in favor of House Joint Resolution 1, can you please raise your hand? And if you are here to speak in opposition to House Joint Resolution 1, if you could please raise your hand. So we will set the clock for 15 minutes. And if you are speaking in support in the room, if you can come on down, please state your name and quickly state your support so that we can all respect the line. Okay, thank you.
Thank you, Madam Chair, and good afternoon. My name is Jerry Greenspan. I'm very happy to be here on behalf of the ACLU of Virginia, which is a proud member of Virginians for Reproductive Freedom, to support this important amendment to Virginia's Constitution. The ACLU of Virginia believes that every Virginian should have the right to chart their own life course, including being able to make their own decisions about whether and when to have children or not. Nobody should fear punishment or discrimination based on these choices or because they accessed or provided necessary health care. This amendment will guarantee these rights for Virginians now and in the future, and the ACLU of Virginia strongly supports this amendment. Thank you.
Good afternoon, members of the committee, chair and members of the committee, excuse me. I'm Nicole Lauder. I'm at Williams-Mullen. I'm here on behalf of ACOG Virginia. Dr. Amy Nelson, who is our legislative chair, literally just had to leave to take care of 3 patients. So I'm going to read her testimony on her behalf. My name is Amy Nelson. I'm a OBGYN in Virginia. On behalf of the Virginia section of American College of Obstetricians and Gynecologists and the Virginians for Reproductive Freedom Coalition, and as a reproductive healthcare professional committed to ensuring our patients have access to a full range of reproductive healthcare services, including abortion care, I would like to speak to the proposed constitutional amendment for fundamental right to reproductive freedom. Women seek an abortion for a number of reasons, and although abortion in the 3rd trimester is rare, it may be medically necessary to preserve a patient's health, future fertility, or their life. Ensuring access to abortion care throughout pregnancy without medical unnecessary restrictions is an important component to reducing maternal morbidity and mortality. The decision to proceed with or end a pregnancy should remain between the provider and patient with as little interference as possible. Because this decision involves unique patient needs as well as inherent uncertainty to outcomes with many fetal conditions. It's important to also ensure that providers have protection from prosecution as they have practiced evidence-based medicine, and I thank you all for including that in this amendment. As a reproductive healthcare professional, I see firsthand the harm arbitrary restrictions on abortion care can cause our patients. Whether our patients are ready to build or create their family, already parenting, or have decided not to continue a pregnancy, all of them share something in common. They are making thoughtful and at times difficult decisions about their health and well-being, and should be able to do this with the guidance of their provider. Thank you.
Good afternoon, Madam Chair and members of the committee. I am Kenda Sutnell, and I'm the Executive Director of Birth in Color. This is a great start for Virginia, and I would like to thank Leader Herring for this historic moment in Virginia, where we have to think about how different every pregnancy is. And so when it comes to fighting for abortion and all of the bans, we have to think about the uniqueness of it. And when you look at Black maternal health, the rate is alarming. And when you look across the United States, what have happened to Black women because of these bans? And so I think that this is definitely important. It is definitely needed. And you can't have it both ways. You can't say, you know, we're going to worry about the fetus and not the mom. And that's the most important piece that we all need to be thinking about and that we all need to be talking about, is how to make sure that Black women are safe during whatever procedure that is needed when their lives are at stake. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Reverend Elisa Aldape. I am an organizer with the Latina Institute of Virginia, but I am also here as a Baptist pastor in a state that is rich with Baptist history. A Baptist history that includes a love for autonomy. HJ1 is a fight to move forward toward autonomy for all Virginians and aligns with the values and overwhelming public support of Virginians who believe that the reproductive health decisions should be private and free from political interference. And lastly, in both roles as a pastor and an organizer, it is my calling to ask who is my neighbor, but not just that, what is it that my neighbor needs? And I'm here to tell you that my neighbor in Virginia needs safeguards to reproductive health care, which will make healthcare safer and more accessible, particularly to those who find themselves on the margins, who Jesus reminds us and charges us to be as people of faith to help and to advocate for. And so support for this amendment is support for healthy, safety, and dignity for all people. And I urge you to join us in advocating for reproductive freedom for all. Thank you.
Good afternoon. My name is Leanne Boyd. This is my son, Declan.
He was conceived through IVF. I just want you to know that IVF is a very important part of reproductive health care, and I need for you to recognize and to keep that as something that is available here in the Commonwealth of Virginia. Please support this bill amendment, and to keep IVF as something that's available to everyone here. Thank you.
Madam Chair and members of the committee, I'm Jamie Lockhart, Executive Director of Planned Parenthood Advocates of Virginia. We are also proud to join our partners who have joined together under Virginians for Reproductive Freedom today. Thank you to Leader Herring for her tremendous work on this historic amendment. This amendment will protect Virginians' right to make their own reproductive health care decisions, including access to abortion, contraception, fertility treatment, and miscarriage care. Right now, with no state or federal protections in place, Virginians face a constant risk that anti-abortion politicians could restrict or ban this essential care. Decisions around pregnancy and reproductive health, including abortion, are personal and private. They should be guided by medicine and science, not by politicians. No one is better qualified than an individual and their healthcare providers to make these complex personal decisions. We've seen the impact of abortion bans in other states, where even life-saving care has been denied in cases of miscarriage and other medical crises. We can prevent this from happening in Virginia by passing a strong reproductive freedom amendment, ensuring that politicians cannot interfere in these critical health decisions. Virginians deserve the security to make choices about their own health, and healthcare providers must be able to act in their patients' best interest without government interference. We urge you to support this amendment today. Thank you.
Good afternoon. My name is Gabriela Watson. I'm the Virginia State Policy Advocate with the National Latina Institute for Reproductive Justice, and we're also part of the Virginians for Reproductive Freedom. My grandmother, an immigrant from Chile, was a nurse who provided abortion care in the 70s. She saw firsthand how access to care saves lives and empowers people to make the best decisions for themselves, their families, and their futures. Today, 50 years later, 13 states have total abortion bans, which place undue burden on Latina communities who are already navigating significant barriers to healthcare access and disproportionate health disparities. I ask you to vote yes and ensure that Virginia protects everyone's right to make private healthcare decisions free from government interference. Thank you.
Madam Chair and committee members, my name is Samira Davis. I am a doula with Birth in Color, but I am also an ICU nurse of almost 10 years, and I am a mother of 2 daughters. I am in full support of HJ1. I left the bedside following the pandemic due to the effects and the lack of preparedness that we had with our patients and subsequently the nurses. I have personally been present for many patients during their last breaths, and I know what it is like to bring somebody back from the brink of sepsis. As we right now are facing a fluid shortage, things like maternal health care and our rights to reproduction are even more important, because if we place our patients in positions where they will have life-threatening circumstances such as sepsis, we lack the ability to provide care already. But if we do it on a legal basis, that is a morality issue that nurses and healthcare providers are not willing to provide, for some of us at least. As I said, I left the bedside due to these issues. If you are unsure what the horrors of maternal health and death can look like when medical professionals are not able to provide this care, I implore you to go and shadow at VCU with the rapid response team or other nurses that are able to provide this care, so that you can see how we are already struggling within the healthcare system. It is hard enough. And I understand that you all feel that this may be rushed, but this has been something that has been happening to women's rights for years, for decades, and the time is now. I appreciate the opportunity to speak, and I hope that you vote yes on HJ1. Thank you.
Good afternoon, Madam Chair and committee members. My name is Mercedes Perkins. I'm a soon-to-be mother who is 38 weeks pregnant. I strongly support HJ1 to secure reproductive freedom in Virginia. My journey through pregnancy has shown me how crucial it is to make personal health decisions without interference or fear of penalty. This amendment ensures that reproductive choices remain with the individuals and their healthcare providers, safeguarding rights around pregnancy, miscarriage, and abortion. I urge the committee to support HJ1 to protect these essential freedoms for all Virginians. Thank you.
Good afternoon, Arena Hicks, Co-Executive Director of Freedom Virginia. Protecting access to abortion is an economic issue. The Turnaway study discovered that women who were denied a wanted abortion have 4 times greater odds of living below the federal poverty level. Reproductive freedom is economic freedom. We strongly support this amendment and appreciate all the hard work from our lawmakers, advocates, and the brave Virginians who have shared their stories. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Laswila Mathias, Executive Director of Progress Virginia. I join my coalition partners with the Virginians for Reproductive Freedom and urge you to vote yes on this constitutional amendment, and I thank the patron for all of her work.
Good afternoon, Madam Chair. I just want to say thank you again to Leader Herring for leading us on this monumental constitutional amendment. In the wake of the most recent federal elections and the overturning of Roe v. Wade, which stripped Americans of their most fundamental human rights 2.5 years ago, the time to launch this constitutional effort could not be more urgent or profound. Every person should be able to decide if, when, how, and with whom to start or grow their families. We are excited to work with you and the committee and Leader Herring and the entire House of Delegates on this monumentous start to the 2-year process for Virginians to be able to decide for themselves about their own reproductive destiny. Thank you so much, and please support this constitutional amendment.
Good afternoon, Madam Chair, members of the committee. Kylie Hines with Equality Virginia. We're a proud member of Virginians for Reproductive Freedom Coalition, and we support this amendment. Thank you.
Thank you, Madam Chair. Joan Port, President, League of Women Voters of Virginia. In the interest of time, I will just say that the League believes that every Virginia resident should have access to affordable, quality health care, including abortion, birth control, and the privacy to make their reproductive choices. We also would like to remind the committee that a 2023 poll of the Public Religion Research Institute showed that 71% of Virginians said that abortion should be legal in all or most cases. Thank you very much. We urge the support of this amendment.
Hi again, Michelle Moffitt, Virginia Civic Engagement Table. In full support of this amendment, it is on us to show compassion and kindness to our neighbors. It's not on us to demonize and stigmatize and act as barriers of care. Thank you so much.
Madam Chairman, members of the committee, reproductive freedom is essential to full humanity. Decisions about bearing children and forming families are among the most personal we make. In that light, reproductive freedom and autonomy are essential to our full humanity and equality. I'm Marge Signer, excuse me. I'm from Arlington, and I'm with the National Organization for Women, Virginia chapter. Thank you so much.
Good afternoon, Chairwoman and the committee. My name is Rhea Simon. I stand before you as a very proud constituent of the Commonwealth of Virginia. I was conceived through fertility treatments through a process called interuterine inception. Oh, sorry, a little nervous. Due to that, I was able to be conceived and give my mom and my father the opportunity to be parents. At the age of 13, I was put on contraceptives for irregular periods. Thankfully, I was, because at the age of 18, 2 weeks after I turned 18, I was sexually assaulted. If I was not on contraceptives at the time, I would have had to have a child. Thankfully, I did not, because I was still, due to that, I was able to go to college and be able to become a career woman and be able to live out the life I want to. I also stand here before you on behalf of my sister-in-law who had a double DNC in the state of South Carolina, and because of their strict laws, she was not sure if she was going to be able to get health care. This is something so important. I have to explain my entire history to you. As a constituent, that is ridiculous. That should be my own private thing. For you to care about me as a constituent, I have to explain all the traumatic things I've been through in my life. Thank you so much. Please support this amendment.
Madam Chair, Jen Strozier, Goochland County, Virginia. I'm here to support this constitutional amendment. We've seen what happens when politicians who have no information about health care or how abortions work or what abortion care is tell women what they should do with their bodies, and what happens is they die, kids are orphaned, and women lose their fertility. So please, I support this amendment. Thank you.
Thank you. If we could reset the clock, and those who wish to speak in opposition to House Joint Resolution 1 could come forward.
Olivia, why don't you get the best people up front? You know who they are. Get the best people. You're the best people.
Yes, you have the floor.
Madam Chair, members of the committee, my name is Amy McInerney from Hume, Virginia. I stand before you as a professional woman and mother of young adult women who are strongly in opposition to this constitutional amendment. I do understand all the rhetoric and rights talk that is surrounding this conversation, but the only words that matter are the words of the actual amendment. And I think that we need to be very careful, maybe hit the brakes, and take a breath, because those words are, many of them, vague, overbroad, undefined, and can leave minors vulnerable to exploitation without parental involvement. The amendment could be construed to strip parental rights, to say nothing of common sense, health, and safety regulations for the women of Virginia. There's also implications for taxpayer funding that need to be looked at, as well as conscience rights. Thank you. Please vote against HJ1.
Madam Chair, my name is Olivia Turner, President of the Virginia Society of Human Life. I won't take up much of your time. VSHL and all of our membership and our chapters throughout the Commonwealth oppose HJ1, both in the original form and this form. Number one, we don't know what's going on with this new version, how it will impact our ability as people in Virginia to pass rational and reasonable protective laws in the future. We know that the original one definitely would have done so. Undefined terms like burdensome, duty, et cetera, in this new version implicate the idea that we cannot even pass bills that would protect women from coercion, women getting opportunities to full informed consent, making sure that conscience rights are protected, and that taxpayer dollars will not be expanded to pay for abortion in Virginia. This is not something that should be discussed in this hasty manner and absolutely needs to be brought properly to the General Assembly for the appropriate debate. Thank you very much.
Madam Chair, delegates, my name is Jennifer Hubert, and I am 22 years old. I've lived in Virginia my entire life, and as a young woman in this Commonwealth, this amendment horrifies me because of the lack of protections in it. This amendment would enable predators while stripping away the ability of parents to protect their underage daughters. When I think about this amendment, I think about my own mother, who was 17 years old when she found out she was pregnant. Yes, she was scared. Yes, she needed help. But this amendment would only have allowed her to be taken advantage of by strangers instead of supported of as she was by her boyfriend, my father, and her family. The care women need today is fully legal in every state, including this one, and this amendment will only cause confusion and predatory behavior. Thank you.
Madam Chair, members of the committee, my name is Dr. Michael Huffman. I'm with the Virginia Assembly of Independent Baptists, and we oppose HJ1. It is an undeniable fact supported by medicine that life begins at conception. Dr. Jerome Lejeune from the Genesis says, after fertilization has taken place, a new life has come into being. The moment that the sperm meets the egg is a medical fact that DNA, which is the string of life, is present. We are talking about a life. We're not talking about a clump of cells. We are talking about a life. Professor Hyman Gordon of the Mayo Clinic said all of the criteria of modern molecular biology, life is present from the moment of conception. Dr. Watson Bowes from the University of Colorado Medical School said the beginning of a single human life is, from a biological point of view, a simple and straightforward matter. The beginning is conception. And if life begins at conception, we are talking about snuffing out of life. And with all due respect, I simply reject the notion of bringing God into ungodly litigation, because the Bible says it is God who's the one that forms human life. Jeremiah chapter 1 and verse 5. Thank you.
Madam Chair, in the committee, I'll cut straight to the point. My name is Andrew Wells. I am a father of two beautiful girls. And this is about protecting children. And this law would put us into a category with countries and provinces that are barbaric. This is not progress. In Germany, there's a 12-week ban on elective abortions. In the United Kingdom, 24 weeks, but 12 weeks in Northern Ireland for any reason. In France, legal up to 14 weeks. Beyond this, they must have 2 doctors' certifications that serious injury will occur to the mother. In Italy, there must be 7 days between when the abortion is authorized and when the abortion is done, and beyond the first trimester, the life of the mother or serious fetal malformations must exist. In China, widely available. In Russia, up to 12 weeks. Beyond this, highly regulated. The first European country to legalize abortion like this was in the Soviet Union in 1920 by Vladimir Lenin. A fetus at 12 weeks. The facts here. It's 3.5 inches big. Most organs are formed. The kidneys are functioning. There is urine being produced. If it is a girl, the ovaries have begun forming. Fingers and toenails are forming. The heart rate will be between 110 and 160 beats per minute. There's major brain development. When pain can be felt is under debate. 24 weeks is the maximum. 12 weeks would be the minimum. It is being studied right now in the Journal of Medical Ethics. We do not know when these babies feel pain. Science is showing us the truth. The world is moving in a direction in this. There are laws on the books in countries protecting children, and I pray that each of you would feel some conviction and protect these children. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Jessie Blakely. I'm here on behalf of the Family Foundation. The proposed amendment to the Virginia Constitution, both the previous one and the amended version, would enshrine extremist no-limits abortion. It is not common sense, and it will result in the loss of human life, not only the lives of the unborn, but also of women seeking care. If passed, Virginia's law would be one of the most extreme in the entire nation. Here is what your proposed language means in practice. This will legalize partial birth abortion. Roe's trimester protections will not be constitutionally allowed. The so-called exceptions in the amended version swallow the rule because mental health can essentially mean anything. This will create unsafe clinic conditions by preventing most reasonable health and safety standards for abortion facilities. It will eliminate all provisions for parental knowledge and consent, not just for abortion, but for sex change procedures as well. This will prevent us from legislating reporting requirements, such as reporting abuse and coercion of women who show up to clinics. It establishes a fundamental right to reproductive freedom, which is vague language that would allow the sterilization of minors without parental consent, the unregulated sale of human embryos, and could open a loophole for people who want to dodge child support payments. This does not restore Roe. It does not protect women. This does, in fact, legally incentivize the type of back alley, low-quality abortions that some of you rail against. It is ideological extremism with no regard for human cost at any stage of life, plain and simple. Please reject HJ1. Thank you.
Madam Chair, P&E Committee, thank you for allowing us this privilege to speak freely concerning HJ1. My name is Teresa Pregnall, and I'm State Director, Concerned Women for America of Virginia, and I speak for our membership here within the Commonwealth. Today, according to Guttmacher Institute, there have been an average of 3,310 babies aborted here in Virginia. There are statutes in both federal and state law that provide protection for the preborn, and yet HJ1, the proposed constitutional amendment language on abortion, is extreme. Only the humanity of the woman is recognized, not the humanity of the baby. HJ1 is dishonest. It denies that women are being pressured to end their preborn baby's life by employers and family members. This is a reality. HJ1 is extreme. A preborn baby could be killed without any mercy up to fully born. HJ1 is deceptive. This amendment isn't about reproductive freedom. It is about a license to end reproduction. Concerned Women for America of Virginia ask you to look closely at how extreme and inhumane HJ1 really is. It isn't about freedom. It's about taking an innocent human life. We urge you to vote no on HJ1, and let's somehow find a way to work together to come to a reasonable solution here. Thank you so much.
Good afternoon, Madam Chair and committee members. I'm Dr. Dennis Petrocelli. I'm speaking for myself, not my employer. I graduated from medical school in 1994. If autonomy and freedom and privacy mean anything to this committee, they would ensure that conscience objections be permitted and protected. As stated, calling these things rights suggests that physicians and other providers could be compelled to do things that their conscience would prohibit, and that is simply untenable. Medical science is clear. Life begins at conception. St. Michael the Archangel, defend us.
I'm Dr. Sheila Fury. I'm the president of the Virginia Medical Freedom Alliance. And I'm going to unequivocally state there is no medical necessity for abortion. None. Zero. This is all based on medical science, and what the delegate spoke of was absolute fear porn. In the first trimester, if a woman miscarries, she is permitted to have a D&C or other procedure by every one of the 50 states. If she has an ectopic pregnancy, that ectopic pregnancy is allowed to be removed in all 50 states. There is no impediment to that in Virginia or any state in the union. In the second and third trimester, if there are complications from the pregnancy, if the mother's life is in danger, we work as physicians to save both the mother and the child. There is no point that you have to kill a child in the womb in order to save the life of a mother. In fact, you can do a cesarean section if the mother's life is in danger in a matter of minutes. Whereas if you're going to do an abortion, it takes 2 to 3 days to dilate the cervix for you to deliver the baby. So if a mother's life is truly in danger, that can be remedied without an abortion and safely without an abortion. For children that are not viable and will not be viable outside the womb, where is your compassion? Where is the compassion of the mother to allow that child to live within her womb for as long as she has the child? This is what we are called to do. We are called to be loving individuals and love the child in the womb for as long as we have that. And there is neonatal hospice available throughout the state of Virginia. Let's do the compassionate thing and care for mothers and all unborn children. Thank you.
Good afternoon, Madam Chair. My name is Naomi Park. I'm a Young Women for America ambassador. I am testifying against this amendment because it destroys the sanctity of life. From the moment of conception to natural death, all life is valuable and worthy of dignity, no matter age, sex, ethnicity, ability, or cognitive capability. Today, I fight against the perversion of God's created order as described in Genesis 1:27, that God created mankind in his own image. My preborn sibling, who died at 7 weeks in the womb, was made in the image of God just like everyone else in this room. It doesn't matter how little a baby is for their life to be valuable. When discussing the life and medical care of pregnant mothers, we must have the conversation of medical malpractice, not the intentional killing of human life. I hope that you stand with me on the side of history that rejects the destruction of life and embraces the marvelous and beautiful miracle of life. Thank you.
Thank you, Madam Chair, for allowing me to speak today. My name is Hallie Gravely. I'm an ambassador for Young Women for America. Children in the womb are humans because life begins at conception, and 96% of biologists affirm that, according to the National Library of Medicine. Psalms 139:13 says, "For you created my inmost being. You knit me together in my mother's womb." Abortion affects 2 lives: the life of the mother post-abortion, physically and emotionally, and it denies a human the right to live. It is not pro-women or women empowerment, but rather an attack on women. I urge you to vote against HJ1 and protect innocent human life in Virginia. Thank you.
Madam Chair Price and the members of the committee, I'm John Mize, and I serve as CEO of Americans United for Life, the nation's premier law and policy organization advancing the human right to life. And I'm testifying today on behalf of AUL and our hundreds of thousands of supporters and friends. I also serve as a board member on Mental Health America. I come to you today to speak on behalf of Virginians of goodwill who support life-affirming law and policy and therefore oppose HJ1. First, I'd like to clarify that elective abortion is the intentional termination of an innocent preborn human life. Elective abortion is not health care. HJ1 swings the pendulum too far toward abortion and on demand when the overwhelming majority of Virginians support a more modest approach, such as a 12 or 15-week limit. Don't be fooled by the changes in the proposed amendment. Abortion on demand will continue throughout the entirety of pregnancy. To address Delegate Herring, there isn't a single law in any state that infringes upon the right for a woman to seek an abortive procedure when her life is in danger. The law in Texas, like other states, is totally clear. There is simply no denying that protecting life in the womb is supported by science, biology, morality, embryology, and all of the major faith traditions. Even the law here in the Commonwealth protects life in the womb, except in the context of abortion. Our fetal homicide law protects unlawful and intentional killing of fetus is a Class 2 felony. My wife and I have been foster parents for over a decade. We've had 30 children in our house, including our youngest adopted son, who was born to a homeless mother who could have had an abortion, but she chose to give Jay life. All life is important, and I urge you to put politics and business and the business model of big abortion aside and think about the real ethical, moral, legal, and societal implications of such an extreme overreach that would allow people to kill their children up until birth if they didn't prefer the sex of the child or if the child was diagnosed with Down syndrome. Thank you.
So at this time, our timer has run out. But recognizing that there are people still in line, I will allow for you to state your name and a statement of opposition. That just means you oppose or you support. I do not have to do this, and I can stop it at any time, so please respect your name and statement of opposition.
My name is Lisa Kratz Thomas, and I am totally in opposition of this HJ amendment.
Madam Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. We strongly oppose the resolution.
Madam Chair, Pastor John Godfrey, Great Oak Baptist Church and Faith Winds. We are strongly opposed to this extreme abortion bill.
Shane Snavely, candidate for the upcoming special election, Senate District 10. I strongly oppose this, and I hope I go to the Senate so I can hopefully combat this and defeat this when it comes to the floor. Thank you.
Good afternoon. My name is Brooke Sadler. I strongly oppose this amendment. Women already have the freedom to murder. We don't need to enshrine it in our Constitution. Thank you.
Praise the Lord. Good afternoon. Pastor Verla Ham. Abundant Joy in Harvest Church. I strongly oppose HJ1. Thank you.
Dana Giammattia, abolitionist in Northern Virginia, and this is my strong opposition to this amendment. This is Christopher.
Good afternoon, Madam Chair and members of the delegate. I strongly oppose. I'm with Students for Life Action, and I strongly oppose HJ1.
My name is William George Devens III, and I strongly oppose this amendment.
Madam Chair, members of the committee, Bonnie Nkrumah with Students for Life Action, lifelong Virginia resident. I strongly oppose HJ1. It will create the biggest violation of parental rights in Virginia's history.
Please remember name and statement of opposition.
Madam Chair, members of the committee, my name is Zach Sprouse. I'm with Students for Life Action. I and the 59 student groups in Virginia oppose this amendment.
Good afternoon. My name is Abigail Meifert, and I'm with Students for Life Action, and we strongly oppose this.
My name is Ryan Holloway. I'm the president of the Virginia Coalition of Pregnancy Centers, and we strongly oppose this amendment. Thank you.
Madam Chair, thank you for extending the time for this. My name is Daniel Heffington. I'm with Generation Joshua, which is a national and Virginia-based organization for teens. We strongly oppose this amendment.
Pastor Rich Pickens, and I start off by apologizing to Mrs. Price. I misunderstood the last time. I thought you cut me off. You did not. I didn't watch my time. I'm here with New Day Church and city elders, and we strongly oppose this.
My name is Lucinda Badone, and I strongly oppose the H.J. 1 amendment.
Madam Chair, C. Greg Carroll, North Springfield, Virginia. I oppose H.J. 1.
Hi, Sherry Britt, and I strongly oppose H.J. 1. Thank you.
Sarah Reddick, I strongly oppose H.J. 1.
My name is Donna Fullahan, and I strongly oppose H.J. 1.
My name is Duke Bendix. My wife Kathy and I both oppose this amendment.
Madam Chair and committee, my name is Michael Gardner from Richmond. I oppose H.J. 1.
Madam Chair, I'm David Lee Stanford. I represent me, and I oppose this amendment.
My name is Lee Ann Stanford. I'm from Charles City, and I strongly oppose H.J. 1 alongside of God who created us all.
I'm Linda Phillips, and as a believer in Christ, I strongly oppose this.
Durana Sylvia, Puerto Rican, and I strongly oppose H.J. 1. Thank you.
Kathy Tankersley, Legislative Liaison for Concerned Women for America. I strongly oppose this radical, far outreaching bill that's vague and leaves too much room for radicalism.
This will be my last warning. Please, your name and a just statement of opposition. Thank you.
Thank you. My name is Ellen Edwards. I'm a resident of Henrico County, and I strongly oppose this amendment.
My name is Dr. Lori Blankenship from Culpeper, Virginia, and I strongly oppose H.J. 1.
My name is Jossie Babin. This is Samuel Babin, and we both strongly oppose this amendment.
Hi, I'm Joanne Elliott from Mechanicsville, and I strongly oppose this amendment. Thank you.
I'm Virginia Lambert, here from Mary's Choice Maternity Home, and I strongly oppose H.J. 1.
I'm Craig Rue, Virginia Chapter Leader for Democrats for Life of America. I oppose this thing.
Elizabeth Block from Manassas, Virginia, and I strongly oppose H.J. 1.
Melissa Calder from Chesapeake, Virginia, and I strongly oppose this amendment.
Robin Smith, just an average mom from Henrico, and I strongly oppose this.
I am Virginia from Virginia Beach, Virginia, and I I absolutely oppose this amendment.
Good afternoon. My name is Ann Robinson, and I'm from Yorktown, Virginia, and I strongly oppose this H.J. 1. Thank you.
My name is Kristen Holtze out of Hanover, and I strongly oppose H.J. 1. What about the freedoms, democracy, fundamental, and civil rights of the freeborn?
You tried it. I'm not going to take it out on you. Please continue with the last warning. Thank you.
Donna Machin, Foster, Virginia. I strongly oppose this amendment.
My name is Gloria Randolph, and I strongly oppose H.J. 1.
My name is Laeth Chevalier, and I strongly oppose H.J. 1.
Thank you. We'll go to questions. Thank you. See, that's what happens when you just listen, please. Okay, so if you are in the online public comment room and you are speaking in support of H.J. 1, if you could please raise your hand and the clerk will call on you. We will have a 5-minute time limit clock. Madam Clerk?
Thank you, Madam Chair. Gail Moskowitz.
Hold on, I'm trying to get my video up.
Thank you so much. And trying to get right here. Please forgive me. I'm trying to get. All right. They can't see me.
That's okay. Go on with it.
Thank you for allowing me to speak today. Since the women of America have been stripped of their access to reproductive health care in every other southern state, we must be vigilant that this does not also happen in the Commonwealth of Virginia. My name is Dr. Gail Shukoff Moskowitz. I'm a clinical social worker and an adjunct professor of social work at Virginia Commonwealth University. I come to you today as a representative of Hadassah, the Women's Zionist Organization of America, an international organization 300,000 strong with 4,300 members who vote in Virginia. We wholeheartedly support HJ1. Hadassah unequivocally stands for women's reproductive rights, empowering women, not elected officials or employers, to control their own bodies and family planning decisions. Reproductive health care choices based on full and accurate medical information and guidance must be made in accordance with a woman's own religious, moral, and ethical values. As a Jewish organization, we want to affirm our stance that in the United States of America, each human being has the right to their own religious beliefs. Much of the language used to draft anti-choice legislation, which I think you've heard a bit of this morning, this afternoon, does not reflect our religious teachings. If you would like to understand more about Jewish laws regarding abortion care, we would be glad to provide it. We urge you to vote in favor of HJ1, and I thank you for your time today.
Leanne Wrights.
Hello, everyone. Thank you for allowing me to speak. First, I would just like to say that, again, there's been a lot of talk of mention of God and religion in opposition. And the good thing about a state-protected access to reproductive health care means that anti-choice members and citizens of our state would still be able to have those beliefs. It simply just means that they can't impose those on other people. I understand the intent and motivations in defining reasonable and quote unquote acceptable conditions for access to reproductive health care, but ultimately we cannot account for every condition and situation, and by protecting reproductive freedom, you allow for all things to be considered by the individual experiencing these situations and conditions and qualified providers who have an understanding of what is needed and required. I encourage you to support HJ1. Thank you.
Alex Sprague.
Thank you. I'll be as quick as I can. I'm glad that Leanne said a lot of things for me. As once again, if you don't like abortions, don't get one. It's simple. And then there's all this talk about, oh, but abortion does this and this and this. Well, let me ask you guys this then. If abortion truly is what you say it is, then how come Dead Red Kansas turns down an anti-abortion amendment? How come Dead Red states like Montana and Missouri voted in favor just this year of pro-abortion amendments? And if you're going to say, oh, well, there's voter fraud, then does that mean John Tester and Lucas Kunce are the rightful winners of those Senate races? But my point is, even if you think Virginia's not going to be like that, let's find that out. Let's send it to our ballots. Let's all decide. It's that simple. Let's do it. Let's go. So please support this amendment.
Aaron Grady.
Thank you. Thanks, Chairwoman, once again for the opportunity to speak on the matter of HJ1, the fundamental right of reproductive freedom. The correct path is clear. Reproductive freedom is a fundamental human right that allows individuals to make personal decisions about their bodies, health, and futures without interference or coercion. The government should have no business determining what happens to a woman's body. Medical decisions are and should be personal. Reproductive freedom ensures that people have the autonomy to choose whether and when to have children, have access to safe and effective contraception, and are able to seek the medical care that they need. This freedom of choice is at the very heart of American life. Freedom from government interference, freedom to act in one's own best interest, and freedom to live a life without tyrannical restrictions. I urge you to support this amendment. Thank you.
And Ms. Kalen, if you could please just state your name and your support.
Yes, of course. My name is Kaylin Vile, and I'm in full support of this bill.
Thank you very much. And so now if you are in opposition to HJ1, if you will raise your hand so the clerk can see you, we will reset the clock. And then you can unmute and come on camera when she calls your name.
Bob Marshall.
Thank you, Madam Chair. I oppose H.A. Res. 1, this abortion amendment, but it's not just limited to abortion. Judges who will have to apply this will look at the words to see where it goes. Because the reference is to every individual without age or sex qualification, that includes males, females, adults, and children under 18, these rights will pertain not just to abortion, but to boys or girls for sex change operations. Will be given cancer-causing drugs without parental knowledge or consent. This, I think, is very imprudent. The additional problems with this is that the laws will be unevenly enforced. They will not be involved with students who are competent with knowledge. Virginia's third grade family life standards, and I hope you listen to this, mentions, and this was approved by Governor Northam, the student will become aware that babies begin with a sperm and egg. This is an age-appropriate, medically accurate introduction to reproduction at the end of 9 months of development. The baby leaves the mother's body. Currently in the Code of Virginia, an unauthorized abortion speaks of the victim of abortion as being a child, not a fetus. So this is an acknowledgement that a human being is being killed. I urge rejection of this amendment. Thank you.
Byron Fox.
Yes. Can you hear me?
Yes.
I'm from Newport News, Virginia. And Madam Chair, thank you. And all of you delegates, thank you. I represent Faith Winds of Virginia, and we have churches and pastors in all 100 House districts. And we stand very opposed to this amendment. We think we should value all human life, the elderly, the prisoners, those with AIDS, the orphans, every category, including the preborn. And someone earlier read from the Bible, and I appreciate that. And the Bible says this, God says, thou shalt not kill. So we stand very opposed to this, and we ask you to vote nay on HJ1.
Susan Musket.
Good afternoon. I'm Susan Musket from Reston, Virginia, and I oppose HJ1 because it is far outside the mainstream values of Virginians. HJ1 can be used to overturn Virginia's current restriction on taxpayer funding of elective abortions. That's what's happening already in Michigan. The ACLU has filed a lawsuit asserting that the 2022 Michigan constitutional amendment requires tax funding of abortion, and that the state law restricting Medicaid funding of abortion should be overturned because it, quote, burdens and infringes, quote, on the right to reproductive freedom of women on Medicaid, and, quote, discriminates, end quote. The Michigan amendment is virtually the same as the substitute before you. And there's no doubt that parental consent for abortion is in the crosshairs with this amendment. In Missouri, some abortion rights groups are publicly complaining about the fact that an initial lawsuit under the Missouri constitutional amendment did not challenge the state's parental consent law. HJ1 could allow minor children to undergo sex change surgeries without parental consent. These are not Virginia's values. Please vote against HJ1.
Thomas Hill.
My name is Thomas Hill. I'm an organizer with Progressive Anti-Abortion Uprising and a Virginia college student, and I oppose HJ1. This amendment is radical and extreme on abortion access. HJ1 would enshrine a right to reproductive freedom into the Virginia Constitution, preventing any limitations on abortion in the first 2 trimesters. We know from other states that have passed similar amendments that the predatory abortion industry will seek to remove safeguards like parental consent from minors and prevent the reinstatement of safety standards. The few limits that this amendment allows in the 3rd trimester are intentionally vague by using the terminology physical or mental health, which can be interpreted broadly to allow late-term abortion in many cases. A woman absolutely has the right to take medical action to save her life, but the language included goes beyond that in the 3rd trimester and allows no 1st or 2nd trimester restrictions. This is a form of abortion extremism. Elective abortion is not healthcare, it is violence, and it certainly should not be a right. This committee has a responsibility to stop this amendment here and protect women and preborn children in our state. Vote no on HJ1. Thank you.
Jason Garwood.
Good afternoon, ladies and gentlemen. My name is Dr. Jason Garwood. I'm a resident of Fauquier County, and I'm a pastor. I'm the founder and president of the Virginia Center for Public Theology, where we defend Christian ethics in the town square. Along with thousands of Bible-believing Christians, and contrary to fake Christians and the horrible theology put forth today, I'm speaking against HJ1, as it is an attempt to permit unrestricted prenatal homicide within the boundaries of the Virginia Constitution. To be clear, this legislative body has already incited the judgment of King Jesus, who is Lord over the state of Virginia, by demanding
Dr.
that no
Garwood,
abortion on top of the
Dr. Garwood, we are out of time. So we have registered your opposition to HJ1. And for the remaining people that have not had a chance to speak, you will have the opportunity to say your name and your statement of opposition.
Shelley Arnaldi.
My name is Shelley Arnoldi. I'm a Fairfax resident and parent, mother of 2. I strongly oppose this. This is not about reproductive rights.
Thank you for your comment. Thank you.
Anna Sisman.
Hi, thank you for the time. My name is Anna Sisman, a resident of Albemarle County and mom of 5 children here on earth and 1 in heaven from a miscarriage, and I register my opposition to HJ1.
Thank you.
Hannah Neihart.
Abortion is murder. Don't even validate this nonsense with a vote. Dismiss it
Okay,
outright.
thank you.
Christina Williams.
Hi, I'm Christina Williams from Fauquier County, Virginia. I'm a mother of 6, grandmother of 9 living, 5 in heaven, and I strongly oppose this HJ1. Thank you.
Nate Gibbons.
Thank you, Chair, for allowing us to express our opposition. My name is Nano Gibbons, father of 4 from Ashland, and I strongly oppose this.
Beth Fox.
My name is Beth Fox. I live in Lynchburg, Virginia. I was not expected to survive my mother's pregnancy, and I am here as the president of Rehumanize International, and we strongly oppose HJ1.
Thank you.
Lacey Holmes.
My name is Lacey Holmes. I'm from Central Virginia. I'm here as a concerned citizen, mother of 4, and obstetric medical professional, and I oppose this amendment.
Thank you. We'll now come back to the dais. Delegate Gilbert.
Question for committee counsel, sorry. Both in terms of the assertion that this is somehow embodying existing state law and basically putting Roe into our Constitution in some form or fashion. Am I correct, number one, that state law, unlike line 24, requires a physician and 2 consulting physicians for a 3rd trimester abortion? And the second question, just because I may not get another chance, am I likewise correct that unlike Roe, in which a compelling state interest existed potentially for the unborn child at a certain point in the pregnancy, that this amendment only applies the compelling state interest to the individual seeking care.
Madam Chair, Delegate Gilbert, so our state code, section 18.2-74, is where we regulate third trimester pregnancies. It does have a carve out for death and mental and physical health of the woman. You're correct that the physician and 2 consulting physicians would certify to that. As to the second question about Roe versus Wade, it's a little tricky to give you a straight answer, but I'm happy to run through the trimester test that Roe established.
Well, am I at least correct that the compelling state interest in this language only applies to the individual seeking care?
That's correct. That's what the words do say, yes.
Okay.
And can you, for the benefit of the audience, go through with your trimester framework? And
Sure. So Roe did establish that the right to privacy encompassed abortion rights, but did also recognize that there were other competing and legitimate government interests that come into play, and they did establish the trimester framework. So in the first trimester of pregnancy, the Roe court established that the woman's privacy right was the strongest interest, and there were no regulations that would be allowed to be enacted for her to seek an abortion. In the second trimester, regulations that were reasonably related to preserving the mother's health are allowed to be enacted. In the third trimester, the state is allowed to regulate or prohibit abortion to promote its interest in the potential life of the fetus, so long as the laws also contain carve-outs where abortion is necessary to preserve the woman's life or health.
Are there any other questions? Delegate O'Quinn.
Thank you, Madam Chair. I don't recall what Delegate Glass referred to this as, but I was wondering if I could have a statement at the end related to the bill, but I'll do it at the appropriate time. No, Madam Chair.
Okay. Let's do questions first.
Okay.
Are there any further questions from the committee? Okay, Delegate Herring, we'll give you the last word.
Thank you, Madam Chair, and thank you, committee members. I just wanted to just point to 2 things from the public testimony and concerns that have been expressed. This does protect current law. Parental consent is the law of the land in Title 16, as well as I heard mention of will allow coercion. Again, that is the law of the land. It does not seek to allow coercion for abortion.
Delegate, please continue.
Yes, I'm sorry. It's all right. It's all right. Continuing on, Madam Chair, just because I was named out about the Texas case, I just urge everybody, we do have to open our eyes and see what is happening in other states that are restricting abortion care, and it is happening. I would say that to those concerned about the language in the constitutional amendment, Michigan has a similar language. Missouri, Arizona, and Ohio just passed constitutional amendments protecting access to reproductive care, and 7 states did just this past Tuesday. In Virginia, as I said, we do have a maternal health crisis and a desert of care. We need to make sure that our patients have access to the full continuum of reproductive care. We have been in a post-Roe world now, and bans of restrictions play out and put patients' lives at risk. Virginians do deserve better, and if we truly want individuals and their families to be safe and ensure that the rights and access to care are protected, we should pass this amendment. Point in case, Madam Chair, we tried to pass access to contraception, make it a right. Our governor vetoed it just a few months ago. This constitutional amendment would protect that. Thank you, Madam Chair.
Delegate O'Quinn, now is the appropriate time.
Thank you, Madam Chair. So somehow or another, I've ended up being the longest serving member on this side of the dais with all 13 years. I was looking on the other side. I think Delegate Sickles holds that honor over on his side. And you can tell he's been here a long time. He had to take like 6 bathroom breaks during this meeting. But nevertheless, truly, this is an extraordinary day because what we're doing here today is
the political equivalency and the functional equivalency of sort of operating in the dead of night, so to speak. And it is very rare to tackle issues of this magnitude outside of session. So I tried to go back and take a look at when that might have been. And I don't want to get fact checked because I'm not stating this as a fact, but I believe the last time was in the 1990s when we tackled carryover legislation like this outside of the normal General Assembly session. And changing the Constitution of Virginia is one of the biggest things that we do as legislators. And it's one of the biggest things we do because the Constitution trumps all state law. It takes 2 years. You can't change the language. It has to go to the voters. And then once something gets put into the Constitution, it is, I don't want to say impossible, it's very difficult to change once it's done. The second point that I would make is that as Republicans, we've become fairly accustomed to being, admonished not to fan the flames of culture wars and leave those social issues alone. And yet, here we are with culture war and social issues front and center. And I understand political theater. I know all the comebacks to that statement. But we've taken a whole bunch of political hot potatoes and brought them into this one meeting today and sort of laid them out here on the table 8 months after session adjourned and 2 months before the next session gavels in. And so I guess I would finish where I started, Madam Chair. I won't trespass on your time, but these are big emotional topics, and the Constitution is a big important document. My final statement is not directed at anyone. It is directed at our institution, which is the Virginia House of Delegates, because regardless of our party, regardless of what we think on these issues, and you've seen mixed votes, Republicans and Democrats, rural and urban and suburban and everything else today, and you're going to continue to hear that debate on these issues. But regardless of any of those particular things, this is something that I personally believe should be done in full session when everyone's paying attention, when we're not suffering from election hangover, and when we are dialed into the fact as Virginians that big things happen during our upcoming 45-day legislative session, and that's when we should tackle really big things like the things that we've tackled today, which would put permanent change into our Constitution. Thank you, Madam Chair.
Yes, and I'll take the opportunity to clarify again that this is a continuation of a conversation that did begin during session, and it is the joint rules that we all voted on that established the November 18th deadline. Now, some of my colleagues to the left, when they were in charge, they chose to do things a certain way. I am choosing to meet the deadline and do the business that is before our committee. These are very big topics. This is a very big room with a lot of people here. We have not only heard from people here in this room, but also we're allowed to hear from people online. And there have been hundreds of emails that we have gotten. Again, these are not new topics. We have tried to pass measures like this before. So in whichever way people want to cut it, I do want everyone to leave with the understanding that we are well within the rules. We are well within the chair's prerogative to have the meeting. And so if you disagree with that, that is fine, but please state the facts. And the political theater part may be something that my colleagues on the other side would wish to associate themselves with. But what I heard was people are dying and that this is urgent and the healthcare needs to be protected. And so for me, that is not theater. I do not have a script. I am not playing a role, anything other than delegate to do my job as chair. And with that, I see Delegate Leftwich.
Thank you, Madam Chair. I speak so infrequently, I couldn't find the mic button. So my apologies. So this is an issue that obviously divides a lot of our Commonwealth, and we can debate whether abortion should be permitted or not be permitted. But aside from that fundamental question, as I interpret this resolution, it would allow abortion on demand up until the very time of birth, which I find disturbing and goes far beyond any third world country that exists on the globe. Secondly, and we can debate this issue, But as a parent of 5, I really believe that if one of my daughters, who was a minor, was pregnant, that me and my mother, I mean my wife, not my mother, should be a part of that process. And this bill would not allow that. And so for those reasons and others that I won't state, are going to lead me to vote against the resolution. Thank you, Madam Chair.
Before I go to the next person, I'm going to ask our wonderful attorney, does the version that is in front of us take away the parental consent for minors?
Madam Chair, on its face, no. With the definition of compelling state interest, it's very possible that if for some reason this ended up at the Supreme Court in a case, they would have to decide that issue if it were challenged. But because of the definition in here, they could find either way. So there's no straight answer, but facially, no, this does not take away the parental consent provisions in 16.1.
Thank you. And I'm sorry, Delegate Herring, did I see that you were itching to make a statement?
Yes, Madam Chair. I just, phraseology that's used to strike fear into people is I have to address it. I believe those who oppose this are ignoring the language in the amendment, which talks about standards of practice. Also in our code, we have a section on infanticide. So I understand what they're trying to do, but that is not within the standard of practice, and that rises to another level of something else. Thank you, Madam Chair.
Delegate Maldonado.
Thank you, Madam Chair. This is difficult, and it's complex, and we have seen in the room, we have seen online, we have seen in our inboxes, we have seen on the ground in our communities, the concern and the passion about this issue. And I want to say that there comes a time when time itself is ready for change. Coretta Scott King said that, and when we look at the long history in our country of controlling women, controlling whether we can vote, controlling whether we can move about, whether we can work outside the house, or what we do with our bodies is well established. This amendment enshrines the rights that are currently existing in Virginia. But I will also say what I love about this is that it expands it to include continuum of care. We are not talking about that today for some reason. But this constitutional amendment includes prenatal care, childbirth, postpartum care, contraception, abortion care, miscarriage management, and fertility care. It is the continuum that continues to be relevant and important to women and people bearing children and starting families in this nation and around the world, quite frankly, as we look at this issue. So I want us to remember, particularly when we think about postpartum care as an example, Virginia is 39th in the country in maternal health outcomes. 39th. That includes breakdowns that are even worse when you start to get to Black and brown communities. And what happens in postpartum experiences, mental health issues, what happens in that very vulnerable time for people experiencing domestic abuse and experiencing domestic postpartum care. Mental health for children. There's been some references to there being mental health considerations. Well, think about Hadley Duvall, who was only 12 when her stepfather raped her and she became pregnant. We need to have protections in place so that we can begin to bring our laws and our protections and our humanity to where the majority of the people are in this country. Standards of care, standards of practice, those aren't determined by the people sitting on this dais. Those are determined by trained, licensed medical professionals. They are doing the work, they have the patient's best interest at heart, and they know how to make these decisions. So I think that we need to remember that none of us up here, None of us in government should be in somebody's ballot box, somebody's bedroom, or somebody's office talking to their doctor. I thank the patron, Leader Herring, for bringing this Constitution amendment forward, and I thank you for the time, Madam Chair.
Delegate Lavere Bowling.
Madam Chair, I have a motion at the appropriate time.
Give me 1 second. Delegate Scott.
Thank you, Madam Chair. Speaking to the bill. Madam Chair, I just would like to reiterate that Council said that the Virginia Code as written right now could be challenged in court and possibly overturned based off of the language of this constitutional amendment. And also, no one here is debating prenatal care because we all believe in that. Nobody here is debating care for childbirth because we all believe in that. Nobody here is debating postpartum care, miscarriage management, or fertility care because those all result in the continuation of life. The topic at hand that's being debated is abortion, which always ends in the termination of life. Healthcare continues life, enhances life. Abortion always ends with the termination of life. Thank you, Madam Chair.
Delegate Gilbert.
Thank you, Madam Chair. I just would be remiss if I didn't say once again that I think, look, there's not going to be agreement generally about this issue, but we are still cleaning up and reeling from the effects of bills on very big, very important topics that were passed in haste with a lack of full reflection, either because of the circumstances or the issue itself. Off the top of my head, we've got an issue we're dealing with in the Crime Commission where we're trying to fix something that happened because it had to happen at the very last minute because of reconciliation in a conference committee, and there were unintended consequences of a very big issue that affects a wide swath of public policy and various aspects of our state and local bureaucracy. We are still grappling with the effects of marijuana legalization, for which no retail marketplace was put in place simultaneously with that. Like these types of big ideas, and I always say, we're not passing ideas here, we pass laws here. This is not just a law, this is a constitutional amendment that's going to trump a bunch of laws, is what I heard, potentially. And to do it this quickly with just one, this is literally the only scrutiny that's ever going to be given to this amendment, because once it gets going, it cannot change. And the type of work, we work on legislation in committee. Moreover, we work on it in subcommittee. Like this would be in a subcommittee where the language would get sorted out. And again, not going to agree on it, but at least we could call everybody's attention to things that we think are inconsistent or go too far. This is our one and only shot at it, and I appreciate so much, and I've told the chair privately, I appreciate her at least letting people come to the microphone and say their name, say their opposition or support, whatever it may be. I do appreciate that. But that's not working on the legislation. That's just letting people be heard, albeit briefly. But getting this right, something this big, again, something with life and death consequences, I think deserves more than just this meeting. I would just beseech the committee, the chair, anybody who's listening who has the ability to slow this train down, to give us an opportunity to actually look at this and discuss it amongst ourselves for more than 5 minutes. Thank you, Madam Chair.
Delegate Lavere Bowling.
Yes, Madam Chair, I'd like to move to report the amendment with substitute.
Second.
It's been moved and properly
Substitute
seconded to.
Motion to lay on the table.
Okay, it's been moved and properly seconded to lay the bill on the table. We will open the rolls and we will record our votes. So that motion fails 9-12. The next, excuse Excuse me. So A, you misunderstood what just happened, and B, we will be very orderly in this meeting, or I will clear the room for us to take the vote. Are we clear? Thank you. What just happened was a motion to lay the bill on the table, which would have been to kill. That motion failed. The next motion in our hierarchy of motions was to report, and that was seconded. And so with silence from the audience and my appreciation, we will now vote on that. And that motion does pass 12-9. I want to thank everyone for, the clerk can close the roll. I want to thank everyone for their time and attention. And though it has been said that there are no other options, that is not true. This is just the next step in the process. We welcome you to stay engaged. We appreciate every single comment that was made today. If you were not able to come today, and we're not able to yet speak, we still have the opportunity on Hod Speak for you to enter into written comment on Hod Speak. We see your emails, we receive your calls, and we have heard from our constituents for years. So we welcome you and your continued input. At this moment, I will entertain a motion to adjourn.
So moved.
It's been moved and properly seconded that we would adjourn. All those in favor say aye. Any opposed? We are adjourned.